Lordship, may I permit to mention, Lordship? Lordship, for upgradation, Lordship, today monthly list item number.
Madam, upgradation mention after 2 weeks. Let us continue.
Lordship, actually, Lordship, urgency is that, Lordship, the contempt application next date, Lordship, 11th August, Lordship, the last chance, Lordship, to kindly, Lordship, take up the matter. Any day, Lordship, 11th August, the next date, contempt application.
Why
The
did
Landed Tribunal, Lordship. WPCT matter, Lordship.
WPCT matter? What is the item number?
Item number, today, item number
Are
173.
you mentioning upon notice?
Lordship, I have already informed, Lordship, over phone, Lordship.
Your Lordship, may I
What is your other side?
Lordship, in person, Lordship, the Sudhir Kumar Bhaumik, Lordship.
Then you give a notice upon him and come and tell us on Thursday. Let us.
May I
Your
permit
Lordship,
to
mine
mention?
is a PIL on Ravindra Sarovar. It was last heard on 27/11/25 with directions to be listed in the monthly list of February. And monthly list of February. And after that, it has not been heard. Now the problem is there is a related matter in the NGT, Your Lordship. They have put it on sine die until the High Court does not dispose it off. And this is a matter pertaining to Ravindra Sarovar.
Take appropriate steps.
Ravindra Sarovar, this is a matter what is of importance from that
No,
matter.
sir, you have to take appropriate steps. There was no interim order in that, only direction for affidavit. So now if a new circumstances occasion, kindly come with an appropriate application.
May I permit to mention? May I permit to mention on application? Sorry.
Milord, may I mention a matter, Milord? This matter was mentioned before, didn't Chief Justice Milord Sujoy Paul Milord Division Bench, and this matter belongs to Milord 1995. Milord,
What do you want, sir? What do you want?
I want Milord that money, compensation money is lying with the Registrar General, Milord. So that sex workers' money, Milord, that sex workers' bodyguard was, Milord, beaten to torture in the Bhawanipur police
No,
station.
you want to withdraw that money. You want to withdraw.
And that sex worker till today did not get it, Milord.
No. What was the order? Last order show us.
Last order, you will also kindly see that order of Justice Mathur, Milord.
This is of 2000, sir.
That middle portion, Milord, you also will find, Milord. That 20,000.
Yes, now Putul Das has been found.
Registrar General, that is.
Have you found Putul Das?
Yes, Putul Das.
Huh?
Putul Das.
You have found her?
Yes. Milord, she has come and she has changed the profession, Milord. And Milord, now she married, Milord.
So you take an appropriate application, sir, in this matter. You want to withdraw the money to be paid to Putul.
I don't know. This is the order of the.
Yeah, understand.
Yes.
The order says that as the whereabouts are not known, keep the amount before the registration and invest in a scheme so that she ultimately.
Police was directed to search that sex worker, but police did not, Milord, search it, Milord.
What did you do for 16 years,
did
sir?
not find, Milord.
This order was of 2000. This order you are saying is of 2000.
This is 2000. Yes.
Please check up the file, apply your mind whether you will make an application or not, and then come back to us.
Milord, the deputy registrar, Milord, read, and the register administration says that file is missing, Milord.
The application has also been disposed of. What are you mentioning there?
That, Milord, that liberty to mention is there. You also will find, Milord, liberty to mention.
So you are mentioning after 16 years, 26 years.
26 years, yes, Milord.
So where from you are getting this idea and mentioning today after?
Milord, that sex work.
All the papers, whether she has been found or not, then
there was a judicial.
You have to show us those documents that the lady is now traceable and she wants to get the money.
May I permit to
Come here,
mention one
Deepak,
matter?
and come and mention.
May I
Yes,
permit
yes.
to mention for inclusion of the matter? My lord, I served the notice, my lord.
What inclusion?
The
Which matter?
tribunal hearing, my lord.
Uh-huh.
Tribunal hearing, my lord.
Tribunal hearing of which year?
Year, my lord, 2023. 2023. No, my lord, 2016, my lord. 2016 hearing. Last.
What hearing you want?
My-
What was the earlier order?
Yes, my lord. Your lordship's order is there, my lord. The application for substitution was allowed, and your lordship fixed the matter for listing, my lord. Thereafter, may not appear, my lord.
আচ্ছা ওটা নিয়ে রাখো সেপ্টেম্বর লিস্টের জন্য। Yes.
May I have your lordships kindly to mention a new Group 9 appeal, my lord, for inclusion, my lord.
Group 9
Group 9
appeal.
appeal, my lord. Mandamus appeal, my lord. It's
Pleadings
a new matter.
completed. Pleadings completed.
Lord, new mandamus appeal, my lord.
New matter, it will come on the returnable date.
Lord, it has not come, my lord. That is
When
why,
did you file it?
uh,
How can it
Lord,
be a
2
new
weeks
matter?
back, my lord.
Uh-huh.
Lord, the date was given for listing on 28th of July, my lord.
So it was appeared on that date.
No, my lord.
28th, it must have appeared.
It has not appeared. That is why I'm mentioning before your lordship, my lord. It has not
চেক
appeared.
আপ করে নাও তো 28 তারিখের লিস্টে দেখে নেবে নিউ মোশন থাকলে তখন দেখে নেবে
I'm grateful to your lord.
Inclusive.
Yes.
My lord,
Yes.
may I please mention item number 505 of the monthly list. My lord, the urgency is, my lord, that liquor license, illegal liquor license, my lord, are likely to be now renewed. My lord, in this writ petition, my lord, there was a direction given upon the parties to put in their affidavits. The matter was, my lord, by consent made returnable on 23rd March 2026. It, my lord, couldn't be taken up, and my lord, since then, my lord, it has gone on to the monthly list. But my lord, we apprehend, my lord, that now, my lord, with the new government having, my lord, come in power.
Remind us after 2 weeks. Yes.
Very
My lord, inclusion of the Group 9 police in action, my lord, it has not been appeared in the,
Hearing.
no, my lord, motion, my lord.
Motion, when was it returnable?
My lord, 27th it was to be listed, but it has not been listed, my
No,
lord.
no, it never happens. In our court, it never happens.
No, my lord, your lordship kindly see, my lord, never it has been mentioned.
ওটা দেখে রেখো তো
Lordship
যদি
kindly see.
এসে থাকে তাহলে বলবো
I have checked every day, but I do not find, my lord, that in the list.
Lord, may I have your lordship's kind leave to mention item number 187 of the
upgradation, please mention after 2 weeks. Yes.
difficulty,
My lord.
my lord.
Come back after 2 weeks.
Field motion, my lord, with notice, my lord.
Motion, new motion.
My lord, earlier Chief Justice, my lord, heard the matter, my lord, the petitioners before your lordship, my lord, they took time, my lord. I am the private respondents, my lord.
So why you are mentioning?
No, no, with notice I mentioned, my lord, because
Oh.
the private
Any
respondents.
interim order is there?
No, my lord, no interim order.
What is your
Let it
problem?
appear, my lord, because of the facts, my lord.
Let them, it is not your child. Yes.
My lord, may I be permitted
But
to
the
mention a matter?
Let them come. Huh?
I mentioned a matter upon notice, my lord. This is a matter with regard to the midday meal given by ISKCON. My lord will recall this matter was taken up on 8th of July when my lord was pleased to pass directions so that affidavits are exchanged within 6 weeks and mentioned thereafter. My lord, in the meantime, an implementation of this scheme took place, and my lord, thereafter we had filed an application which was returnable on the 31st of July.
You are for whom?
My lord, I am for the petitioners.
My lord, I am for the state led by learned AG, my lord.
It is
Your lordship,
mentioned
My
upon
lord,
notice.
my lord, we'll file one affidavit bringing all the facts in this CAN application, my lord. So your lordship may
There
fix
is
the
no
matter accordingly, my lord.
application was never taken up, my lord. We are just praying that the CAN application be listed so that it can be taken up. It is a PIL.
When did you file the CAN?
My lord, it was returnable on 31st of July.
We passed any order.
No, in CAN, my lord, it CAN never was taken up, my lord.
Then what was
My
returnable?
lord, the main writ petition was taken up by your lordships on 8th of July. When my lord,
It has not come.
no, my lord, it was not supposed to. My lord, on 8th of July, when my lord had taken up the main PIL writ petition, my lord had been pleased to pass orders exchanging affidavits, which would have taken the clock to 6 weeks thereafter. My lord, in the meantime, the implementation took place. Hence, we filed an application. And my lord, that application was returnable on 31st of July.
That application was returnable. But when did we keep the main writ petition?
After 6 weeks from 8th
So
July.
any interim order you are seeking in
My
the
lord, in the application we are seeking an because my lord,
we will hear it along with the main matter.
My lord.
Let them give the opposition. You mention it thereafter before us.
lord.
We will enlist
my
it.
lord, only will my lord recollect my lord on 8th of July when my lord was passing
We
the orders.
We
My
understand.
lord, it had
The
fallen from my lords that
opposition is ready.
My lord, we have almost readied the opposition, my lord.
written it up here.
Yes. You do it within a week. So
My
that
lord,
they
we'll
can
do it
use
in a
to
week.
reply.
My lord, we'll do it in a week.
You after they give it, you come and tell us. We will consider. Yes,
Well,
yes, yes.
But there is an extremely urgent Port Blair matter, my lord.
All are urgent.
No,
Mr.
because
Samanto. Whichever matter you mention, it is urgent. Tomorrow I will die.
Demolition and sealing of hotel, my lord. Single bench has passed
You
the
are in
order.
hotel business also, Mr. Samanto. Now, what are you doing? I don't understand.
My lord will kindly grant leave to file without certified copy. We have made application.
When was the order passed?
31st, the order was passed. First, we made the application, and it
What
naturally,
is the urgency?
my lord, demolition and sealing of hotel. We have a permission for running the hotel, notwithstanding
Leave
that.
granted. Yes.
May I be permitted to mention two MIL matters? Your Lordship, I'm mentioning with regard to WPA 260 and
What
262
do you
of
want,
22.
sir? What do you want?
The matter was about to appear in the list on 3rd of July, but the matter didn't
Was
turn
it
up.
given direction by the previous bench?
Yes, it was given by the erstwhile Chief
You
Justice.
hand over the slip. Let us check up for a new.
Much obliged.
My lord, may I
How many matters you are giving?
Two matters.
Check
Two
up
matters.
Matter
It was assigned matter.
assigned to our bench.
Your Lordship.
Are you sure?
Your Lordship. It was assigned to court number 11, the earlier bench of Your Lordship. And
It is an education matter.
no, it is an PL matter regarding to the independence of FSL.
Peel matter বলছে কি order আছে দেখি
Your Lordship, we have mentioned the matters couple of times and it was allowed.
Yes, you agree. That is why the matter was adjourned.
Your Lordship.
Yes.
My lord, may I be permitted to mention a tribunal hearing of 2013? My lord had earlier directed that the matter should appear in the monthly list of August. My lord, it is not there in the list, lordship. I'm mentioning again, if my lord may.
চেক আপ করে নাও আসেনি কেন লিস্টে তাহলে পরের সেপ্টেম্বরে কম্বাইন্ড লিস্টে দিয়ে দেবে
My lord, deeply obliged, my lord.
Yes, call the list.
The application Mr. Harjaj is appearing online.
Now, in this matter, when we moved without, we had expressed our apprehension, they might without take adverse action unless some interim order is passed. My lords were kind enough to observe that such situation arises, please approach the court. Not we are approaching the court seeking my lord interim order, the eviction should not my lord, be undertaken till
We
the
have
matter
kept
is
it
not
on
decided.
13th August, Mr. Bhattacharya. We have
Yes.
kept it on 13th.
Yes, but in the meantime, my lord, they have already, my lord, organized the all logistics, my lord, to evict us. That's why, my lord, we are before a lordship. That's the application. No, let them not take any adversarial action till 13th August. Lead my harder on 13th August. I have no difficulty.
Yes, Mr. Bhattacharya.
But on the last occasion, my lord had directed me, my lord, to come back with the necessary instructions. So this project is aimed towards, my lord, the security and sovereignty of India, my lord, which is undertaken by, my lord, the Union of India.
Pardon.
This particular project, my lord, this is undertaken, my lord, in the interest of the security and sovereignty of India by, my lord, the Land Port Authority of India. The project.
Now, what happened? Are you doing anything prior to 13th?
My lord, I have taken instructions. My lord, this Fair Compensation Act, this is not applicable because the entire land vests on the state. It's a vested land. The state, my lord, working
Very
in
good,
tandem.
but we have kept it on 13th.
Yes.
Is there any immediate possibility of any eviction? Then we have to hear Mr. Bhattacharya.
My lord, the work is underway, my lord. The Land Port Authority, they are undertaking the work. We facilitated. There were certain encroachers, my lord. Now, they are not entitled to receive any compensation, but since, my lord, they were encroaching on that state land vested on the state, there was some form of compensation money which was paid. So it is not their land. I can come back with, my lord, all instructions, my lord. This is, my lord, the skeletal instruction that I have received.
No, but they are apprehending that they may be removed.
No, my lord, what my instructions provide, my lord. As per the field inquiry, there are only 2 Paka and 7 Kacha structures that are standing. Rest are all areca nuts and teak plantation. So these are all on the vested land of the state, my lord.
No. We have been given settlement in vested lands. We cannot be thrown out like that.
What is
Just-
your instruction, Mr. Tiwari?
My lord, what is happening, Lordship? It is, as very rightly said by my learned friend, Millard, it is a particular project of national importance because it is the border. Now, Lordship, the land was given to us by the state government and the work is going on because this cannot be stalled, Millard, on a mere apprehension, Millard, and this is of national importance. As far as work is going, it was going on when the writ petition was filed, when this public interest litigation was filed at that point of time, Millard. Now, all of a sudden, they have come up with an application on 31st. I could not have a word with the authorities because Saturday and Sunday being holidays. What we have gathered is from the state government that this land does not come within that settlement. And
is there any apprehension that
My lord, will
whatever
kindly-
is there that will be removed? Please help. We do not want to embarrass the advocates because
Have you taken instruction? My lords will, in that situation, my lords, may keep it tomorrow, my lord. Let me take proper instruction in writing because my understanding is that since the matter is pending and we have already informed them verbally, they will not take. But, my lord, as I am a creature of instruction, let me come back, my lord, tomorrow, my lord, with proper instructions, my lord, because we could not get a time.
Strategy come back tomorrow.
But kindly only, my lord, takes note of the instruction, my lord.
We are not going any
The
lengthy.
matter is fixed on 13th
My lord,
August.
short
Let,
point. Short point.
let
The
them
land
not
in
do
question,
anything till 13th.
the land in question, my lord, it is 122 acres of land. Now, it was earlier leased out by the government, my lord, to Messrs. Torsha Tea Company Private Limited.
Yes.
And it has been resumed, my lord, vide an order dated 4/12/2023, and thereafter it has been handed over to the Land Port Authority. So, my lord, the persons who are, my lord, saying that they are the owners, etc., my lord, they do not have any right. Their case is that why will they not be paid in terms of the Fair Compensation Act? But unless and until there is a title, but they are not entitled. The state government, as a solatium, my lord, for shifting them, since they were encroachers, granted them.
How many petitioners are here? Poschimbango Cha Mozdur
Plantation Workers Union. Milord, this is a huge human problem. Now, kindly Milord takes it up on 13th August. I shall show who are encroachers and who are
Let them
really
at least demonstrate that they have some form of title over the land.
I need not have
It's a
because I
vested
was
land.
settled there by government.
It's a vested land.
Mr. Bhattacharya, if you kindly come to page 154. It appears there was a meeting amongst the authorities and your union members.
Last occasion, they have said this is a conference building meeting.
That's why I say, Milord, they have been doing all unilaterally.
My lord, it is that
They say we will give you this money, go
My
out.
lord will kindly see.
These
Kindly come to
plantation
page-
workers.
My lord, 154, lordship.
Mr. Bhattacharya, kindly come to page 155.
Yes, that I had referred to your lordship on the last occasion.
Representatives of the land sports informed the chair that compensation to the affected dwelling houses would be paid in accordance with the provisions and approved rehabilitation framework, which will be 5,50,000.
No, the people who were there, they were not our representative.
My lord,
These are
our instruction.
all not unilaterally managed.
This meeting was held on 4th July 2026.
Yes.
Now, what happened thereafter?
Nothing has happened. Milord, after we moved the court, now we have instruction. They have Milord, organized logistics to remove us.
Applications are filed like this. Kindly come to the next paragraph. The representatives of the LPAI assured the minister that 70 numbers of members of the group would be accorded priority concept for engagement in project. There was a meeting, there was a settlement.
Milord, this settlement we are saying, no, we did not. No, that's my point. These are all Milord hand-picked, managed people, Milord sitting them together. They wanted to get away. But that's our demands. Milord, these people were brought in.
How can we, out of the villagers who attended, there were 53 persons. Where is your statement? Which person is there? In which land? What interim order you are wanting?
No, I am only
Just an
seeking-
omnibus direction we cannot pass, Mr.
No,
Bhattacharya.
I am
You also take instruction as to whether they have received any compensation or not. They have agreed to this or not.
Milord,
Joint
I have
meeting,
said
Mr.
so. Milord, that's my PIL, that this is all Milord stage managed. They have done all unilaterally. Milord, let them now remove till 13th. We shall see and come address your lordship.
Testing my patience.
Milord, these
The
poor people
particulars of land is
were brought
appearing in
in
the
from
prayer.
Chotanagpur for the purpose of tea plantation, and then they'll
What
remove.
interim order we will pass? Tell us.
Milord, not to Milord remove this person, still Milordship
Without
does.
knowing who are the persons and who
I have
attended
given on.
the meeting.
I have given Milord some details. If necessary, we shall supply the details to
No,
them.
you come on 13th. If there is eviction, then we will consider. If this undertaking is broken, we will take effective
And my lord,
steps
page 156, we have
I-
annexed the
Blood,
chart.
blood,
along with the writ petition.
blood, lead,
Mr. Tiwari,
lead.
you take
My
instruction
lord, I shall written instruction.
and apply your good office. If we are in
Yes, let us see.
you apply your good
My lord, I
office.
will apply my.
13th August along with the
My lord, deeply
yes,
obliged.
next.
Grateful to your lordship.
13th. No, only
Five.
what is the appearing online? That's why I'm not being able to communicate.
Come on 13th. Communicate there.
In the meantime, they are removed. That's the whole difficulty.
No one appears on behalf of the next item.
6 minutes, I beg to appear on behalf of the petitioner, lordship.
And for the respondent also.
You're for Union of India.
Lordship. Lord, I have prepared a short list of dates. Lord. Lord, the brief facts of the case is, Lord. Well, Lord, the brief facts of the case is, Lord,
We're
the
ready now. Yes.
the respondent, Milord, was Milord charged of Milord having excess cash and Milord allowing Milord the passengers of the second class Milord second class to Milord the AC two-tier coach. Milord, this was the two Milord charge leveled against him. Milord, the initially Milord the inquiry report Milord dropped the proceedings and Milord disciplinary authority Milord accepted the same. This is an admitted position. Thereafter, Milord, after Milord, the change of the disciplinary authority, Milord, the re-inquiry process was initiated and Milord, there was a direction passed. And Milord, the private respondent also Milord attended Milord, the re-inquiry proceeding. Milord, subsequent to that, Milord, the private respondent Milord challenged by your filing an original application before the learned Milord Central Administrative Tribunal bench. Milord, by virtue of the order impugned dated Milord 7th of December 2016, Milord, three Milord notifications, rather Milord memorandums for initiation of re-inquiry
The
process.
order now. Where is the order?
Milord, the last order dated 7th of December 2016, Milord.
7th of December.
My lord.
2016.
16.
Then what is this order? You have come up with an application for appropriate order.
Milord, that is Milord with regard to Milord the second original application filed Milord claiming Milord the admissible dues.
Default. Matter was dismissed for default, lordship.
Right, it was restored.
Restored.
Thereafter restored, lordship. After dismissed for default, no case is there. I filed the contempt application before the Honorable Tribunal. Honorable Tribunal not taking the point. They only charge us giving the discipline proceeding is stop, drop. That's why they are not giving anything. Thereafter, I filed the original application for retirement benefit, lordship. I am already retired. I'm filing the original application, that order was giving the release the or determined meaning. Thereafter, they restored the application, Lordship.
Now, this 20th of February order has not been challenged by them.
Yes.
No, my lord, that is not challenged.
Subject to the outcome pending.
Admissible dues, my lord, to be released, my lord. That was the direction, subject to outcome of this, my lord.
Where is the order you are challenging?
My lord, the order, my lord,
Order original
pended
notice,
to my lord,
Lordship,
WPC.
7/12, 2016, Lordship.
আচ্ছা, এটার সাথে কোনো লিস্টে অ্যাপ্লিকেশন রান করছে কি?
না,
একটা আছে। Order challenge.
Parent order, my lord, the last order, my lord, to the petition, 7th of December 2016.
Just let us go through it.
Well,
Where is your memo dated 3rd December 2012 directing re-inquiry?
yes, my lord, page 42.
Page
42.
Sure. So this is after about 1 year from the date of dropping the proceedings. Proceedings were dropped on 25th
Yes.
August 2011.
My lord.
And this memo was issued in
Lord, it is 30th of November.
November 2012, about 1 year.
Well,
Who is the CO? CO means the
charged officer. Charged officer.
Charged officer. So what order is this, Mr. Chakraborty? This order is being passed since the CO did not get an opportunity to defend. But it was held in favor of CO. Why he will unnecessarily?
This has a this has an history. Lordship, may kindly have a look to page 40 for a moment. My lord, the memorandum dated.
We shall go through.
My lord.
Judgment ছিল
Yes. Lordship, may kindly have a look to my lord. Rule 10.
One procedural aspect
Yes.
and another aspect is a substantial
Yes.
matter.
Lordship, may kindly.
Procedural, that some procedure has not been followed. Now that not be a observation of such procedure will affect the decision.
My lord. My lord, that is exactly, my lord, the
That
view of the
materially
disciplinary.
affect the decision.
My lord.
So it is general comes that non-compliance of such forfeiture, if cause prejudice to the person concerned, he can come claim for remittance. No, no. And due to non-observation of certain procedure, it has affected the decision making process and affect the decision. Then it will be remanded.
Grateful.
Reconsider it.
My lord, I'll just take your lordship to page 40 of the petition.
Page 40.
My lord, it is, my lord, it is, my lord, the charged officer, my lord, who, my lord, gave representation for filing, my lord, additional documents, as well as, my lord, lordship kindly sees for him, my lord, this 26th of October 2012, my lord, memorandum was issued. It is prior to, my lord, page 40, 40.
The points raised by yes. Application for additional defense documents shall not be entertained. He could have been prejudiced, Mr. Chakraborty.
My lord. Now lordship kindly considers after this, my lord, he again, my lord, gave a representation at page 41.
Very good. That I want these documents.
I want to, my lord, he sought for clarification.
But the ultimate order went in his favor, Mr. Chakraborty.
In his favor. Now, my lord, the problem arises.
Did he make any prayer to you that you have wrongfully set aside the disciplinary proceeding? It was on a deficient inquiry report. Consider these documents and again pass a fresh order.
My lord, what happened thereafter? My lord, the again notice was served from our end. My lord, he participated in the process again. The re-inquiry process was initiated and he participated.
India fighting against a what? Group D. কি পোস্টে কাজ করে?
My lord, he was CTO, Group D. CTO, Group C.
Group C. TC or TC.
3 বছর ডিসমিস হয়ে পড়ে রয়েছে, then you
Thereafter,
No, lordship.
আবার take your seat. Take your seat.
Now, lordship may kindly have a look to my lord, rule 10.
That has been quoted in the order.
My lord, rule,
Very good.
yes. My lord, rule 10, if your lordship kindly sees, my lord.
So your first submission is pages 40 and 41 show that the petitioner, charged officer himself wanted to adduce some documents. So the inquiry was conducted without abiding by such relief as claim. Can that be a ground for re-inquiry?
My lord, the ground probably was taken was of biasness. My lord,
Where
Lord,
do you find?
by virtue of, my lord, the
No, sir.
30th of November's, my lord, memorandum at page 42. My lord,
42, yes.
your lordship was looking at. Lordship kindly sees, my lord, about second paragraph.
Yes.
It seems that charged officer was not given opportunity as per rules to maintain natural justice, which may imply
Why
biasness.
the inquiry which was not accepted has to be reopened? If natural justice was not given to him, he would have been the sufferer. Then at his intense instance, you could have taken a decision that a re-inquiry is required.
My lord, may I clarify, my lord? So far as, my lord, his instance is concerned, my lord, we initiated re-inquiry process. He participated and then withdrew. My lord, he probably didn't, my lord, understand, my lord, what was the consequences if he participates. Once he has, my lord, become wise, my lord, he withdrew himself and, my lord, challenged, my lord, the proceeding before the, my lord, by way of filing an original application before the learned, my lord, Central Administrative Tribunal.
No, he challenged the re-inquiry direction. He didn't challenge the disciplinary proceeding earlier.
No, he didn't challenge the disciplinary proceeding. My lord, what he challenged, my lord, he participated in the re-inquiry process. If your lordship kindly comes, my lord, to
Mr. Chakraborty,
my lord.
his participation will not legalize the proceeding which is illegal void in his view.
I understand.
Now we are taking this, since he participate, it has been legalized.
Now, my lord,
Don't say whether
now
initiation of a re-inquiry proceedings.
then lordship may kindly have a look to rule 10.
Legal or not?
Rule 10, my lord.
Yes.
My lord, rule 10's 2. My lord, rule 10, my lord, may I just read, my lord?
Where you are reading?
My lord, I have handed over, my lord, the copy of rule 10, my lord.
Last page.
My lord, the last page I posted, my lord.
Just 1 second.
এই পরের ইয়েটা দিন তো ওইটা আমার
এই ক্যান ফোর্ডের কপিটা কোথায় সাইকেল he retired when did he
30th of September 2016, my lord, paragraph 3 of the judgment, my lord.
what was the punishment imposed after re-inquiry? Any punishment in
No, my lord, it was going on. He challenged and my lord, it was quashed.
it was quashed. Now withholding court said that you make an in the second original application you were asked to comply and he was asked to give an undertaking.
Yes.
Then what happened thereafter?
My lord,
Did you
thereafter,
get
my
the
lord, the
benefit?
contempt application is pending on 11th.
Oh,
thereafter net comply the order, second order, I file the contempt application.
Acha, that is pending.
Pending, that is pending.
Fixed on 11th.
You are 2013, you have not yet got your pensionary benefits.
No, that's
2016.
2016. Return September 2016.
My lord,
Full 10.
my lord, the last page, my lord, I posted, my lord,
Yes.
with yellow. With yellow, my lord,
Yellow flag.
top of the
Oh,
page.
Rule 10, which portion you are reading?
My lord, 10(1)(b), my lord, action on the inquiry report. If the disciplinary authority, my lord, may I just read?
10(1)(b).
B.
Action on the 10(1)(b). Yes.
If the disciplinary authority is not itself the inquiry authority, may, for reasons to be recorded by it in writing, remit the case to the inquiring authority for further inquiry and report, and the inquiring authority shall thereupon proceed to hold further inquiry according to the provisions of Rule 9 as far may be. So, my lord, this is the provision, my lord, for my lord, further inquiry. Now, my lord, if your lordship kindly comes back, my lord, to the order impugned, my lord, the order impugned, my lord, has gave a reason that it is, my lord, after acceptance of, my lord, the report by the disciplinary authority, it cannot be reopened, which is my humble submission is incorrect. Lordship kindly sees, my lord, the order impugned for once.
Yes.
My lord, internal page 5, paragraph 6, my lord.
Paragraph 6, last portion.
Yes.
Yes, please.
My lord, may I just, in view of the aforesaid factual matrix of the matter, we are of the view that the reference which has been placed on record, cited supra, with regard to further inquiry, does not extend any help to the respondent. We may observe that as per the rules and reference cited supra,
Now,
it is
wait,
within.
wait. Reference and rule cited supra is paragraph 4.
My lord.
You have given a reply supporting the order of re-inquiry on the strength of comments appended to the rules about the action to be. Where is this portion? This is from which portion it has been taken?
My lord, this further inquiry, my lord, we have given an explanation to the rules. My lord, it can be, my lord, under 3 circumstances. My lord, the first circumstances.
You passed in your, this you incorporated in your reply.
My lord.
This is any quotation from the rules?
No, my lord, I believe that is, my lord, from the explanation, my lord, we have given.
Explanation.
It is not from the, it is, my lord, given by the, my lord, by the tribunal.
No.
My lord, quoted from our reply.
quoted herein below for ready reference.
Yes,
This
from
must have been in your reply.
From our reply, my lord.
So in reply, you relied upon this.
Yes.
What is this?
My lord, this further inquiry process, my lord, is depending on three scenarios. My lord, one is, my lord, documents, my lord, which are not proved. The second is, my lord, the adjournment denied. In case of adjournment denied. And my lord, third is absence of, my lord, defense counsel. These are the three grounds. Your lordship will get it, my lord, rule 10(1). My lord, the first one, my lord, about the circumstances which has been specifically mentioned. 10(1), lordship, kindly have a look to. After considering the inquiry report, is of the opinion that further examination of any of the witness is necessary in the interest of justice. It may recall
This is at the stage of first inquiry.
First inquiry.
Disciplinary authority may direct re-inquiry. In this case, you have not directed re-inquiry. You accepted.
We have accepted.
Then how can you apply this rule?
My lord, now, my lord, 1(b).
Yes.
Is not itself the inquiring authority may, for reasons to be recorded by it, in writing, remit the case to the inquiring authority. My lord, this is post, my lord, inquiry report.
No, post acceptance of the inquiry report.
That is not clear, my lord. My humble submission, post acceptance, my lord, is not specifically mentioned.
Read the rule fresh. It starts with action on the inquiry report. We are at a stage where action was taken. It was rejected. This is subsequent thereto you are issuing the order of re-inquiry.
My lord.
So how rule 9 or 10 applies?
My
My
lord, I leave it to your lordship. My lord. The new incumbent came and my lord, my lord, remitted the matter back for
how? There is a procedure, inquiry report, then it will go to the disciplinary. Disciplinary authority may remit it on the conditions provided under Rule 9. Here that is not the case. Here, inquiry report was accepted by the disciplinary authority. About 1-2 years thereafter, your new disciplinary authority.
My lord, that is, my lord, the case. My lord, I leave it to your lordship.
Now, if we dismiss it with exemplary cost, you will go to Supreme Court.
No, my lord.
We know this is your nature, that you will not allow that Group D officer to get his family pension or pension. He will die in the meantime. You are successful enough.
No, my lord, already contempt proceeding pending and fixed on 11.
Tell
We
us
have
about
to.
contempt in tribunal. Don't tell us.
No, I leave it to your lordship. This is, my lord, so far as I have.
What is your last explanation? Your paragraph 6 you are reading. We will not stop you. Please tell us.
Lord,
paragraph 6 of the impugned order. You are placing.
My lord, lordship kindly sees, in view of the aforesaid factual matrix of the matter, we are of the view that the reference which has been placed on record, cited supra with regard to further inquiry, does not extend any help to the respondent. We may observe that as per the rules and reference cited supra, it is within the competence of the disciplinary authority to remit the matter to the IO for further inquiry if any deficiency is noticed in the report of the inquiry from a particular stage. But the circumstances given in reference are prior to acceptance of inquiry report submitted by the IO and not after acceptance of the report of the inquiry. This is not the explanation. In the present case, we find that the disciplinary authority, after considering the records and report of the IO, had taken a conscious decision to drop the proceeding and exonerate the applicant from the charges leveled against him. In these circumstances, the successor in the office of the disciplinary authority cannot reopen the case and direct the de novo inquiry by framing fresh charges on the self-same allegations. It is also not in dispute that fresh inquiry was directed on the self-same charges on which, after due inquiry and upon consideration of the report of the inquiry, the disciplinary authority dropped proceeding exonerating the applicant from the charges. In view of the discussion made, my lord, thereafter, my lord, the three, my lord, notifications, my lord, quashed. My lord, I leave it to
The
you, my lord.
present writ petition has been preferred.
to take necessary instruction with regard to service upon the respondents. Malat, Mr. Chittopriyo Ghosh, Malat, I personally contacted him. He said that he has no contact with his client.
Yes, directly to the client.
Yes, Malat. Malat, let it appear in the next monthly list. We will apply for certified copy. Our records are also from the erstwhile advocate. We could not retrieve the file, my lord. We need to have a certified copy. We cannot copy
Certified copy
of the pleadings, my lord. We could not retrieve the pleadings of the erstwhile advocate from.
What is the order impugned here, Mr. Banerjee?
Nothing is here.
Oh, nothing. No record is.
No record is with us. That is the reason we have to apply for certified copy.
Say this. Demanded back to the appellate authority to issue
appropriate order.
So by the order impugned, the original applications were disposed of, remanding the matters to the appellate authority. Then why you are agreed by this, Mr.
My lord, only I will just see the records, my lord, and thereafter your lordship may conclude the same. My lord, since we cannot get this.
No, Mr. Banerjee, you can ask your junior to go through the file.
Yes, ma'am.
And take instruction on that. Maybe it is unnecessarily pending.
Only for 1 week, your lordship gives me accommodation. I shall see your lordship's file and argue that.
No, we will. We keep it in the next monthly list.
Next monthly list. My lord, that will.
Meantime, you take written instruction.
Yes, ma'am.
If unnecessary.
Unnecessary. Otherwise, I will say before.
Next monthly list. Yes, next.
Please
Please go through the file. Ask your junior.
Yes, my lord. We shall. We both shall. We both shall. Grateful.
Don't pray for adjournment, madam.
My lord, that is my instruction to be specific. My lord, my senior, Mr. Nilanjan Bhattacharya, is indisposed. My lord, I'd be grateful for another adjournment.
What happened?
He is indisposed due to certain medical conditions, my lord, and the situation persists still.
What happened? Everything is.
Has considerably fell down. Almost down to 5.3, 5.4. Hemoglobin level has come down. He is admitted in Apollo Hospital.
That has been challenged, and I'll be retiring within 6 months.
Retiring when?
6 months, December. I am not opposing the prayer. I cannot.
All right.
This is the problem.
Next monthly list. But ask Mr. Bhattacharya that we have given. This is an issue of the person will be retained.
Again, I'll be troubling your lordship with mentioning and all that. Your lordship is covered with so many matters, my lord. Kindly give a date, specific date, my lord, subject to my lord's pleasure.
Date, Mr. Samanto, that will create another problem. If it is not taken up that day, it will continue to hang in the list. So it is fairly at the top. In September, it will be reached. You tell us if Mr.
Lordship will grant us liberty to mention also, my lord, so that because otherwise, Lord, we will 2013 matter. After 8 years, it was decided by the tribunal in my favor, and
we will. Nine.
I'm for the response. Oh.
You are this side. Oh. Who is your other side, Mr. Sound?
Lord, we have given notice to Mr. Shovik Nondi is there, Lord, and
What is land losers?
no, this is not land use.
What is this?
Lord, this is a matter relating to
Land palleter.
short point is my lord, whether departmental promotions could be granted to reserve category persons to unreserved posts. Already Supreme Court is in session of the matter. Their DOPT has filed a circular. That circular says that it cannot be done, and because the matters are pending, and he talked to me, Mr. Shatra talked to me today morning. He said, I don't have the brief. So I said, then you tell the court that I've shortened the issue through the CAN application.
Supreme Court is in session of the matter.
Is in session, but then DOPT has issued a circular saying that it cannot be done. Irrespective of that, we will not do it.
Your Lordship, Mr. Nandi is appearing in this matter. He, due to personal difficulty, has not come to court. I was praying only not today. Let it appear tomorrow, Your Lordship.
My lord.
Next week.
Not today.
I'm grateful.
Sorry.
Yes, next.
No, it's okay. Where was there?
কালকে আবার not today হলো তো order তো
Lord, I am for the appellant.
Petitioner.
Petition.
I'm
Appellant.
of India.
Petitioner. This petitioner.
Where is the order impugned? Which is the order
impugned? Page 42.
Date of the order. 26th February.
26th February.
42. What is
49, 49.
What is the date of the order?
Date of the order is 26/2/2004.
Check up and say. 2004 na 11.
4.
Order impugned কত বলতে?
2004.
26th February 2004.
2004. Kindly appreciate. Earlier, Your Lordship,
পড়ে দেখি। Where is the pension adalat order?
Page 31.
And where is 12th of December 98 memo?
Page 31.
Page 31.
Page 31.
Pension adalat order.
Pension order.
What is page 31? Reference.
3132.
She is not entitled to pension as her husband was a DC gangman. She would get terminal gratuity as per serial 4686. Where is that? Serial 4686. Where is that?
Directed to produce that upon. They were directed to produce the job in earlier occasion.
Huh?
And report was called for, my lord. That was order on 22/2/2024. 22/24. This is ordered. They were directed to submit the report.
Why haven't you filed the report? We directed filing of a report by an order of 22nd February 2024.
Report in the form of affidavit. I have already filed.
You have filed?
Yes.
Where is that? You have got the copy?
Yes.
Then why you are saying?
My lord, report is totally suppression of all the facts. Two cases has been decided by the Honorable Cat Bench. One Bhadu Devi and one Khiroda Devi. Bhadu Devi and Khiroda Devi. One case in Bhadu Devi, there was direction to give the pension. Khiroda Devi, based on Bhadu Devi, that was given for consideration. They did not give the Bhadu Devi. They challenged before the Honorable High Court. And Honorable High Court, Honorable then Justice Pranab Chatterjee has decided in favor of the Bhadu Devi. Thereafter, they have given the pension to the Bhadu Devi, but still the Khiroda Devi is not given.
Where is that High Court order? এখানে আমরা আগের অর্ডারটাই বলেছিলাম।
I have not taken it, but I am giving the what is the report. Not They only have that, totally Milord, suppressed all the facts in the report. I must say one thing, one interruption, Milord. After filing of this report, much later, they have amended the prayer.
Yeah?
Prayer portion, they have amended. Can
What
it be
amendment? What amendment?
kindly see?
How does it affect?
Actually, washing is not there.
That quashing order was not there.
That's why we have can file.
Sir, we passed an order in February 24.
Yes.
Saying that when you have given to a similarly situated person, why you are not giving?
Yes.
What is your reply to that?
I have replied.
To us, to us.
Yes, yes. First of all, kindly appreciate, my lord. This person was appointed in the year 1979. Page 3 of my report.
Yeah, let us go through your exception.
কিছু নেই। Report.
This OA 542 was preferred by whom? What was the name of the petitioner?
Krishna Chatterjee.
That is in this case.
In this case.
The similarly situated.
Bhadu Devi.
Till?
Bhadu Devi. This is the order, my lord.
Bhadu Devi.
Bhadu Devi.
This OA 542 of 2013 was preferred by Bhadu Devi.
542 the 542 seven. No, Khiroda Devi. It is Khiroda Devi. Khiroda Devi. This is Khiroda Devi's order. Khiroda Devi.
Khiroda Devi they have dismissed, contempt has been dismissed.
Yes, this is the point, my lord.
Not
This
only
is the
that,
point,
they
my
have
lord.
suppressed.
You please see the Khiroda Devi's order. You please see the Khiroda, my lord. And that was based on Bhadu Devi's order. And Bhadu Devi, they didn't give it. They came to the Honorable High Court. Based on Bhadu Devi.
This High Court order is passed in whose favor?
Bhadu Devi.
Bhadu Devi.
This is Bhadu Devi's order.
Bhadu Devi we have got.
This is the central administration. 542 is my lord Khiroda Devi.
Where have you stated about Bhadu Devi? Sir? In your exception, where have you stated about Bhadu?
Bhadu Devi. I am coming to that.
You have given Khiroda Devi and Udgi to do. Where is Bhadu Devi?
Pagdi to do. Kindly comes to page 5, paragraph 7.
That is Khiroda Devi.
No, Pagdi to do.
Read. Instant case is
last paragraph. That page 5, my lord, of my report. That another similar case before the Honorable Supreme Court in the SLP number Pagdi to do versus Union of India, judgment was passed dated such and such, thereby Honorable Apex Court dismissed the petition on the ground that ex-employee Shona Tudu, her husband, Pagdi Tudu's husband.
You are which report you are reading from?
Page 5, my lord. This is the report in the form of affidavit.
Here my brother has got one copy, I have got another copy.
But I have filed 2 copies, my lord. Can I hand over, my lord, this copy, my copy?
The decision in Biodevi, even in as the ratio design. is similarly situated with that of Khiroda Devi.
No, no, that would be to do. 8 typographical mistake. That would be 8. Last paragraph. 8.
কোথায় 7 তো
Eight.
Last paragraph. Last paragraph. 8 no para is there only.
Last para, sir. We are reading here.
Yeah. Page 5.
The
Last para নেই. 7 is the only para. No, 8 is Oh, indicated.
अच्छा
अच्छा. Oh, 8 is indicated.
अच्छा, अच्छा,
Only one para. That is my lord typographical mistake for us. This means no same. Kindly text this page.
Arey, sir, we can take papers which are already on record.
My lord, I am sorry, my lord.
আরে কিভাবে tell us
এই তো আপনার
where you are reading, tell us.
হ্যাঁ ওইটা জজ সাহেবের কপিতে পরের পেজে চলে গেছে।
Tell us where you are reading.
Another similar case.
Which line?
Middle paragraph, my lordship's.
This
yes,
one.
Yes. Para 7.
Another similar case, which line?
7 বলুন না, para 7. 7, para 7.
এইটা নেই, ও যেভাবে করছে সেটা নেই।
Another similar case এখানে নেই।
No, page number 6.
Page number 6. Page number 5 এ দেখাচ্ছে। না ঠিক আছে, ওটা জজ সাহেবদের কপি।
From last portion, that is in the brief of the my lord, the last portion, para 6. Last portion of page number 5.
Yes.
And the 6th page most probably is omitted.
এটা দিয়েছে প্যারাগ্রাফটা এখানে। এই যে এইটা শেষে in our view decision in বিয়াদো দেব।
In our view.
In our view, Beoda Devi, even if applied.
Yes.
So page 7 টা এইখান থেকে আছে।
হ্যাঁ। Page is perhaps mismatched, my lord.
Where you are reading?
Oh, reported. No. I am reading from that another similar case before the Honorable Supreme Court in the SLP number such and such, Pagdi Tudu versus Union of India and others. A judgment was passed in such and such date. The Honorable Court, Apex Court, dismissed the petition on the ground that the ex-employee Sona Tudu, the husband of the Pagdi Tudu, was not a regular employee, and the claim for pension under the Rule 75, Sub-Rule 2 of the Railway Services Pension Rules 1993, and rejected the claim of family pension because the applicant's husband was not covered by the definition of the term railway servant contained in the Rule 2, Sub-Rule 23 of the said rule. I have annexed it, my lord. And the said rule, the said SLP arose from the WPCT number 87 of 2010, and the said WPCT was dismissed by the Honorable High Court by judgment dated 10/8/2011. And the operating part of the judgment, we have considered the rival contentions. We have also perused the decision of the Apex Court in the case of Prabhavati Devi versus Union of India, reported in such and such, relied upon Mr. Banerjee to support his contention. In our view, the decision of the case of the Baidu Devi, that may be the Bhadu Devi, even if applied, would be no consequence, as the ratio decided therein is no more a good law in the view of subsequent decision of the Apex Court in the case of Secretary, that is Uma Devi. Right. My lord, the decision of the case of the Prabhavati Devi Supra would not be applicable. The concerned employee was not a regular staff. This is our point of the railways, although he might be enjoying regular pay scale after decasualization, and this person was a gangman, decasualized gangman. Joined in the year 1973, died in the year 1983, only 4 years of service. Now, taken in the railway side, it would be entitled, not be entitled to any retirement benefit, including family pension, which they have relied upon. Now, my lord, kindly comes to paragraph 7.
Okay, we are actually here in the present case.
No, they have relied upon. They relied upon the judgment.
Listen to what my brother is saying.
In the present case, the Krishna Chatterjee was
Krishna Chatterjee, wife of the deceased.
The husband of Krishna Chatterjee was appointed as TC gangman.
Gangman.
That meant decasualized.
Decasualized
That
gangman.
is no more casual.
No.
That is the point. Okay. Gangman in 1979 and died in 83.
83.
So here the pension rule applicable for the railway employee who appointed after 1964 will be applicable.
I'm coming to that.
1964 rules.
Or will be applicable. Now you come to page 22 of your report, 75.
Yes.
Yeah.
1 year continuous.
Therefore,
75.
He has, before his death, he completed 1 year of service.
Yes.
Here condition was that whether the particular employee completed 1 year service or not.
Yes.
64, that rules. So he completed 1 year service.
Yes.
So his wife or family left by him would be entitled to family pension.
No. Why I am telling you.
Yeah.
Before that, kindly comes to page 5, paragraph 7.
Of your report?
My report.
Yes, that in that two case, Pagu Devi and
No. They have relied upon Khiroda Devi.
Forget about the judgment. First act.
No.
First act.
Khiroda Devi is important. Why I am telling you, my lord?
Judgment. So
no.
Whether
Khiroda Devi was challenged and
Listen to what my brother is saying, then answer.
My lord.
Whether that two judgment will be applicable or not, then the fact of those two cases is to be considered first.
Yes.
Okay, whether there was a actual similarity or not.
Yes.
Now, you kindly consider you are claiming in that circumstances, Supreme Court came to a conclusion that those employee cannot be stated to be regular railway employee.
Yes.
Now, regular railway employee, you relied upon this decision, 223. Okay? 223, who has been kept out of the purview of regular railway servant. That means the person who is not holding any post under administrative control of the railway.
Yes.
So you can say that a DC gangman is not holding a post under administrative control of railway. It is your case.
Yes. Now I am coming, I am answering. I am replying. Kindly comes to page 32, Supreme Court judgment. Page 32, I have annexed of the report. Of the report.
Tell the fact of that case.
Similar fact. Similar fact. I am reading it.
Yeah. Okay, similar. But
that is Pagdi to do that it has been relied upon by the petitioner. It has been kindly appreciated. It has been relied by the petitioner.
I am reading it.
না আমি বলছি দাঁড়ান আমাকে জিজ্ঞাসা করেছে আমাকে উত্তর দিতে দিন Yes, no, this is Pagdi to do. Page 32.
We have got Khiroda Devi.
No, Pagdi to do. It is Pagdi to do. Pagdi to do versus Union of India and others. Last annexure. Annexure P5.
Yet we are considered.
Annexure P5. I am reading, my lord, paragraph A. Paragraph A of that judgment. Late Sona Tudu, the deceased husband of the applicant, was a casual gangman with temporary status. The applicant, in her representation dated such and such, he has mentioned that her husband was a decasualized gangman. Kindly appreciate, my lord. Similarly situated petitioner. Huh?
You read.
Yes, my lord. The factual position of is as follows. Casual labor in the railway were initially engaged on casual service on daily rate of pay and were not entitled to get regular scale of pay. After the introduction of the scheme of decasualization, the daily rated casual gangmen were given regular scale of pay. This, however, did not confer on them right to regular employment. Such casual labor on completion of 120 days of service in open line and on completion of the 180 days of the construction organization were eligible for being screened for gaining temporary status. Regularly posting after gaining temporary status is not mandatory and is dependent on availability of vacancy. Thus, the position remains that Sri Sona Tudu was not posted as a regular employee. B. Late Sona Tudu was not a pensionable staff as he was
not on Sona Tudu. We are
similarly situated, decasualized gangman.
Listen to us.
Yes.
You listen to us.
Yes.
In the case of Biyado Devi,
Baidu Devi, yeah.
Baidu Devi, she was given pension.
No.
Supreme Court admitted.
Kindly comes. Baidu Devi was considered in this judgment also. In this judgment also.
In this judgment?
Yes.
Yes. Show us where Baidu Devi.
1 minute. Next paragraph, my lord. After C.
Bhadu Devi, yes.
Bhadu Devi, huh? Next, the petitioner challenged the aforesaid order in OA number such and such. The tribunal referred to Rule 75 of the rules. Is also ordered that such and such passed in OA number such and such in Bhadu Devi versus Union of India and others. I carefully examined the fact of the case in Bhadu Devi's case. The husband of the applicant in the said OA number 79 such and such was a regular employee. He was in a pay scale, was kindly appreciate, he was a regular employee, Bhadu Devi. Was in a pay scale of rupees 200 to 250. Accordingly, he was considered as a railway servant. He was considered as a railway servant under the definition of Rule 2 of Sub-Rule 22 of Railway Servants Pension Rules. When the employee was a regular employee, then he was eligible for pension. Accordingly, the wife of the said employee was given family pension. In the present case,
so that
it is not the specific contention.
That person was of Bhadu.
Bhadu Devi.
So Bhadu's husband was a regular employee.
Regular employee.
But Krishna's husband
he was not. He was not. He was never.
He was a casual labor.
Casual labor.
As a casual laborer, he was placed in a regular scale.
Yes.
Then he was decasualized.
Decasualized.
After decasualization, you are saying that he cannot be treated as a railway servant since he worked as a
decasualized gangman.
That is decasual prior thereto.
Yes.
Prior thereto, he was not a regular employee.
Not regular employee. Never.
You were a regular employee prior thereto.
Never. That is my point.
He was casual gangman. That was the status of the casual when he absorbed. On that time, he is decolorized. He was decolorized when he is going to be absorbed. One list is prepared. Bhadu Devi is clear. He was also decolorized gangman. Bhadu Devi.
Don't hand over papers.
No,
answer our question.
My lord.
Where have you stated
Bhadu Devi,
Krishna Chatterjee's husband, was he a regular employee?
Never stated.
Decasualized gangman.
That was subsequently, prior there.
Prior to that, he was casual. Thereafter, he was decasualized. And same status, Bhadu Devi.
No.
And the
no, Bhadu Devi says.
Bhadu Devi is different.
Come to page 32. Page 33.
33, yes, my lord.
Kindly come to page 33, second paragraph. I carefully examined the facts of the case in Bhadu Devi's case. Husband of the applicant was a regular employee.
Yes, but he was not.
Supreme Court has told, but the Bhadu Devi.
There is the distinction.
Wait,
I'm sorry, my lord.
Earlier cat's order, there is specification is there.
Husband of the petitioner.
He was also decasualized. Bhadu Devi's husband also was decasualized employee.
He was decasualized, casual prior thereto.
Yes. Prior to he was casual.
No, prior thereto he said he is a regular
casual.
Employee.
There were decasualized.
Read the order. Come to page 33.
I have carefully examined the facts of the case in Bhadu Devi's case. The husband of the in the said way was a regular.
Wait here. Husband of Bhadu was a regular employee. You were not a regular employee. You are a casual.
No, my lord. I am decasualized. Decasualized means I am regular temporary employee. And 1964 family pension rule is there. Family pension rule, my lord.
Okay, the difference in between these two cases, say the.
No difference.
1 minute. At the first case, discussed in page 32, let Sona to do such and such. It is the first case. Here, this person also casualized gangman. And then the next case, which was discussed in page 33.
His case was rejected.
Bhadu Devi.
Bhadu Devi.
Here, this case has not been rejected. Why?
No, rejected. Kindly come. No, no. Bhadu Devi cannot be rejected because he was a regular employee.
He was.
But this husband of this person is not, was not.
You draw or you are given a regular scale of pay.
Yeah, my lord, regular. May you please, may you please see the my.
Have you annexed any
Yeah,
document?
Thanks. I have annexed it.
Regular.
Page 36, my lord.
Of your
Page 30, no,
of your way.
Read petition, page 36. No,
Page 36 is
No.
pension form, sir.
That you are drawing a regular scale of pay.
Yeah. I was given the regular scale of pay.
Page in the
Date of application 23/4/71. 79.
date of
As a
initial engagement as casual labor on April.
As a DC gangman. Date of
It was a casual labor.
initial engagement as casual labor on 1/7/71.
Casualized করা হলো.
Date of birth 5388. PF number
casual হিসাবে করছে
450126.
79.
He was appointed as a general laborer on 71. Thereafter decasualized.
casualized gangman.
They are not regularized.
No. Please check up. Decasualized gangman, if they have worked for 3 years, they are treated as regular.
No,
That caption is there.
No, in this case, he was not.
এই 2026 এর AIR টা আনাও তো, রিসেন্ট ভলিউম। We may add, page 33, we may add that the petitioner's failure to produce any document to show that her husband had been regularized or that he had been granted regular scale constituted a valid ground for not entertaining her claim. But here it is your case that he got a regular scale, but he was not regularized.
Not only, he was on the decasualized list. My lord, may please see the 1964 family pension rules. I have already annexed it. This is clear.
Yes.
Page 44.
Yes.
Casualty that will arise. That's why the railway board has actually
44.
44.
Yes, they show us. What you are showing us?
And it's a family pension.
Which way did Yes, what are you showing?
46, my lord.
Yes.
Page 44, Family Pension Rules 1964. The provision of these rules shall apply to a government servant entering service in a pension establishment on and after 1st January 1964.
And it will show that Bhadu Devi will not be applied in Karnataka. In view of Uma Devi, কেন এটা বলছে? In our view, decision in Bhadu Devi, even if applied, would be known as the ratio. There is no more a good law in view of Uma Devi. A key গল্প petitioner was not a regular staff. Temporary status a regular staff.
And at page 46, really pension rules is attached. Page 46.
Page 46.
46. Really pension rules. Page 46.
Yes.
Para 18. Pensionary terminal or death benefits to temporary railway servants. A temporary railway servant who retires on superannuation or going retired private healthcare on further realization by the appropriate medical authority after having entered temporary service not less than 10 years shall be eligible for grant of information. But in the event of death in harness, a temporary railway servant, his family pension shall be eligible to family pension death gratuity on the same scale as administered family pension railway servants should this.
Try to understand. He was as a general, he was a laborer.
Labor.
Temporary status. Temporary status casual was subsequently regularized. But in the present case, before your regularization, you were decasualized.
Thereafter regulation comes in, my lord. After casualization, when he is decasualized, he comes within the regular temporary employee.
Right.
He comes within the provision. That's why 1964 family pension rules, 47.
Yes.
47, 1970, that was actually adopted for the casual employees.
47, yes.
Page 47, my lord.
Yes, what you are showing, page 47?
Page 47, my petition.
We are on page 47.
75.
Yes, read.
The provision of this rules to apply. Yes. We a railway servant entering service in a pension establishment on or after 1st June 1964. We a railway servant who was in service on the 31st December 1963 and came to be governed by the provision family pension scheme for railway employee rules 1964 contained the railways board's letter number FP 63 PN 40 dated thereto was in post immediately before the commencement of these rules. The provision of the husband 2nd September 19 railway servants or pensioners who have died, retired or died before 1963 also to those who were alive on the birth pay had opted out of 1964 scheme.
It is not applicable to you according to them.
Yes.
You are to show that since you became a decasualized gangman, you acquired the status of regular employee, or even if you didn't acquire that status, you are a temporary railway employee, yet you are entitled to get your family is entitled to get family pension.
I am showing.
After demise of the employee. Yes. You have to show this, satisfy this thing.
দেখো দেওয়া আছে 539টা দেখো তো দেওয়া আছে কোথায় 539 539 দেখো এই যে My lord, 41 539, page 41.
Yes.
The family pension scheme is applicable in case of regular employees on pension settlement. As such, casual laborers will be brought on pension establishment only on their absorption against railway temporary post. It follows that they will come under the purview of the scheme from the date of their absorption against the regular temporary post. Because it means he has been absorbed for regular temporary post. After declaration, he is absorbed, automatically absorbed. In other words, the family pension scheme will applicable in the case of death of such an employee who are in service only he have completed the minimum period of 1 year service from the date he has absorbed against the regular temporary service. Declaration means he has been absorbed in regular temporary service. No.
Casual labor, when you are appointed in 71, from 71 till decasualization, you continued as a casual laborer.
No, my lord. Casualty has ends. Actually, one express in Bhadu Devi, he was also the cat.
Again, you are going to Bhadu Devi. You are not answering our question. Our question is, after 1971, when you entered as a casual laborer, till 1979, you worked as a casual
No,
laborer.
my lord, I was decasualized in the year 1973.
79.
79.
You were decasualized in 1979, paragraph 2 of your
79.
original application. So this 71 to 79, their contention is you were a casual. You were not a regular employee. As such, you are not entitled
No,
to pay.
after 79, I have been.
আবার 79 এর গল্প করছেন। After 79, he became decasual.
Yes.
Then there was a screening test for regularization.
Yes.
You could not appear there because you died in 1983.
Bhadu Devi case is the same already.
আবার বলে Bhadu Devi, you answered our question na.
Actually, I was in the cleaning list. I was.
Bhadu Devi was a regular employee.
No, he was not a regular.
Kindly come
Bhadu
to
Devi's
page
husband was a regular employee.
You may please go to cat petition. You may please go to the cat petition.
No, come to
original petition. Original petition.
Page 33.
Page
of my report.
of the
Original petition, cat
Of my
petition. You go.
report. Page 33
Original cat
of my
petition.
report.
Cat original. Page 4. This Bhadu Devi cat's order. Bhadu Devi cat's order. Original cat's order. There will be totally described about Bhadu Devi.
That was
her husband.
That was
has been described in the original cat's order. Bhadu Devi's husband was a decasual employee.
আবার বলে we are saying that you were a casual in 1971. Show us that prior to 79 you were regularized. এটা হয় কি করে?
79 were decasualized. Please go to the cat's order. You may please go to his cat's order.
Page 33 of their report.
Yes, page 30.
This is the cat's order. May you please see the cat's order, my lord.
Forget about cat's order.
No.
Cat's order, it went up to the
That is
Supreme
the
Court.
originality of the case. Originality of the case.
It went up to the Supreme Court. So all order passed in Bhadu Devi's case
was
merged with the Supreme Court's
Yes.
order. Now read the Supreme Court's order. Now read the page 33, that portion.
Middle portion.
Kindly assist us. When the applicant is not able to prove, applicant means in Bhadu Devi's case, who was seeking family pension.
Bhadu Devi.
That her husband was a regular employee. That means two conditions.
Yes.
And she was in the pay scale of such and such. I consider that the husband of the applicant has not fulfilled ingredients of such and such. Accordingly, applicant has not made out a case. Respondent was justified by issuing interim order. So ultimately in Bhadu Devi's case also,
yes,
the family pension has not been granted.
No, Bhadu Devi granted.
Bhadu Devi granted.
Bhadu Devi granted.
Bhadu Devi was husband of Bhadu Devi was regularized. That's why he was granted. But this case he was not regularized.
To show that your husband was a regular employee and he was enjoying a scale of pay.
Scale of pay.
So even if you can prove that your husband was enjoying a regular scale of pay,
Regular pay, I have.
but you are not in a position to show that he was a regular employee.
Yes.
I am showing it that he was in regular scale of pay.
Page
200,
42 of the writ petition. Even if it is assumed.
You file an exception to this report. And
No,
bring
they have
on
filed,
record.
my lord.
They have filed the exception.
Yes, yes.
Exception.
No, we have not filed an exception.
No, they have filed.
We have not filed an exception.
He's saying you have filed.
No. We have not.
I am searching, my lord. Perhaps they have filed.
Have you used an exception to this?
Yeah.
Where is that?
I have not taken exception. I have not given. Actually, they have filed it.
Which copy are you having?
Their copy.
They show us that. The একটা রিপোর্টে এই করেছে একটা রিপোর্ট
এটাই বলছি
এটাও টেক ব্যাক
Obliged.
পন্ডশ্রম ওকে ওই ভদ্র the exception you show us that your husband either you have to show that a casual employee who was subsequently decasualized and regularized will come under the purview of Rule 75 of the pension. Are you following? Don't show Bhadu Devi. You place your own case. You were a casual. You were decasualized. And thereafter, you could not attend the screening for regularization since you expired. In such circumstances, whether you can be brought within the definition of railway servant under the pension. This is the only point.
And kindly direct them, my lord, to annex the pension adalat copy, my lord. They didn't. They haven't annexed.
Yes, next matter.
Pension adalat.
For the respondent.
Lordship, I am for the petitioner in this matter. We learn this is the 2023 matter. Mr. Ashok Chakraborty was appearing in this matter. I have not been able to brief the learned ASD, Mr. Dheeraj Trivedi. Your Lordship, I'm praying only for a week's time. Your Lordship, next week we shall.
What I appeared?
Your Lordship, the learned.
Oh, so
the new ASD have not been able to brief him, Your Lordship. So I'm praying for only 1 week's time.
But they are done.
Your Lordship,
You
the
are
learned
competent
senior
enough.
is there.
What is the matter? Removal? Huh?
Your Lordship,
Clear
I
proceeding.
No. My lord,
prepared a project
not
of
getting the
days.
family pension from the railway authority. My father was the assistant station master appointed in the railway, my lord, in the year 1953, and then thereafter subsequently a departmental proceedings. Due to that departmental proceedings, I was removed, and thereafter I came before this court seeking for the papers to be handed over in the departmental proceedings. High Court has allowed, the Honorable High Court has allowed. Then thereafter the second round of litigation, I came before this High Court. By that time, my lord, I was removed. So since I was removed, I had to challenge that order. That order was passed by the Railway Board. So jurisdiction of Delhi High Court was invoked. I went before the Delhi High Court, then challenged. Delhi High Court passed an order for reinstatement, and I was reinstated by the Railway Authority from 1957, since when I was removed from the service. Thereafter, they did not pay the they did not pay the gratuity and other benefits. For that, I had to file a suit before the Alipur court, and Alipur
That
court,
has
my
no
lord,
bearing on this case.
Yes, then?
then, my lord, I got the order from decree from the Alipur court challenging that decree. My lord, they come before this High Court and they lost in the appeal. The certain period, I did not get the benefits because of the fact that Delhi High Court passed an order for reinstatement from 1957.
So decree was satisfied. Money suit decree was
Yes,
satisfied.
yes. Subsequently, they paid.
Acha. That money suit was pertaining to your retiral dues.
No, no, I'm sorry, my lord. That was for a certain period. They say that I was absent from the office without.
Was a list of.
My lord, I have got the list of them. My lord, I'll get it xeroxed. And
Down. You don't have
Your
an.
Lordship, I have prepared one list of dates and I've handed to your Lordship.
I'm sorry, my lord. Whether I have given the right one? No, no.
1953, first, he was placed under suspension.
Let us. Dismissed from which date?
57, 25th July 1957.
The third column in the list of dates, your Lordship.
25th July 1957. He was terminated.
Yes.
Now, this reinstatement order of Delhi High Court is dated
13 July 1973.
13 July
1973.
73. Reinstatement with effect from 57.
With effect from
Achha, that reinstatement, in the meantime, you expired when? You expired in 93 thereafter.
Yes.
So after reinstatement, what did you do?
Actually, I rejoined on 21st August 1974.
21st August
1974.
You rejoined?
Yes, I rejoined because they had admitted before the suit court, as also they had admitted in the suit court that there is a delay.
Understand the problem.
I'm sorry.
57 you were terminated.
Yes.
Delhi High Court in 73 state, you were reinstated. You rejoined in 74.
74.
Then what happened?
Then
you died in 93.
Yes.
Then what happened? In after
10th February 1978, I had to I had obtained the decree from the Alipur Civil Court.
That is separate issue.
That is for the money suit.
We don't know what word did use you. We are saying your claim here is that as I am reinstated, I am entitled to my back wages and everything from 1957, from the date of my dismissal.
Yes.
Then what is the story
I
about?
retired in 1978.
1978.
Retired.
30th September
30th September 1978.
Then what happened?
Well, during this period, I was on leave. 74 till 78.
You joined in 74, you said?
Yes.
Then why on leave?
Well,
During this period means which period?
I'm sorry, Malad, I short
You
mistake.
retired when? 78?
30th September 1978.
Very good. So from 57, you rejoined in 73.
74. August 74.
So after 74, you worked for 4 more years.
I was on leave.
So from you were on leave from 1974
till
78.
78.
After rejoining, you took leave.
Yes.
Then no disciplinary proceeding.
No. No.
Then what happened?
Well, I died in 1993.
সে তো অনেক পরে হলো তারপর what happened 78
Now I am the daughter of
that we know you are 7 siblings, you are one of the unmarried. Yes. Now what was your prayer before the tribunal?
Seeking for family pension as also all
one at a time. Direct the respondents to sanction family pension since the date of retirement, as well as gratuity provident for relatives. Memo dated 28th December 2016, which you challenged.
Manoj is referring
your prayer before the cat.
28 December 9, 2016.
Yes.
By which your prayer for grant of family pension was rejected.
Page 70. 70 of the OA.
Page 70.
Not in the writ petition. My lord will not find because they have not annexed perhaps the OA.
Your Lordship, we had handed over the annexures to the OA separately when the matter was taken by the ordinate bench, Your Lordship.
You people are also not in.
Your Lordship, in this manner, the annexures were
where is the order of 28 February 2016? And nobody considers this matter. Year-long matter is in the combines. Tell us, 28 December 2016, where is that order?
Kindly, they have handed up a bunch of documents. It won't be. This is the first page, and in this bunch, my lord, will find at page 770. Thank you.
What did the tribunal ultimately direct?
The tribunal has held that it was not fault of mine because I never got the chance, and as per 54, Master Circular 54, tribunal has quoted that 54 Master Circular, all employees who have been appointed on the date, there is a cut-off date, 1963. So I got appointed in the railway, I got the appointment in 1953. So I am entitled to get the family pension. I can take your lordship to that relevant part. Master Circular 54, tribunal has quoted that.
Page 17 is the master circular, Your Lordship.
Kindly come to
And
the...
their case is that your father did not opt for.
Yes.
It is that
I say that option is not required. It is automatic. And I'll be relying on a Supreme Court judgment of 1990, which says it's automatic. Kindly come to page 12, internal page 12 of the tribunal's order. Tribunal has quoted the entire Master Circular number 54.
December 2020.
ঠিক আছে, পেজ 70 কেন
ওরা আলাদা করে ওয়ের সঙ্গে অ্যাটাচ ছিল, এটা ওয়ের অ্যানেক্স। ওয়ের কপি করে দাও।
Where is that provision for exercising of option?
There is none, because kindly come to internal page of tribunal's order, impugned order, page 12. Kindly come to para 6.
Yes.
There is a reference of Master Circular number 54. My lord has got it. Yes. My lord, kindly come to the from 20, tribunal has quoted the entire thing. The rules contained in this manual govern the pensionary benefits of the following classes of railway servants. Number 1, A, then B. Now, my lord, kindly come to, I'm coming under Roman 2. Kindly come to at page 13. All non-pensionable railway servants who were in service on 15th November 1957 and who elected to come on to these rules.
Elected, Your Lordship. That means they have to apply for that option. Your Lordship, page 17 is the master circular.
Come to you. All non-pensionable railway servants who were in service on 5th November 1957 and who elected to come on to these rules.
Yes. Now, my lord, kindly come. 85 ta dekho.
So you have not exercised that option.
I did not get that was the finding of the tribunal.
Now,
because I was removed.
You were removed you were terminated in 57.
57. July. Cut-off date is 11 November 1957.
11 November 1957.
15th November 1957. By that time, I was removed.
This is to the relevant rules. This is Railway Pension Manual.
Yes.
You are reading.
Yes.
So where is that?
Page 17.
Was that order by which it was rejected? Now it will
Your
be
Lordship,
clear.
That is at page.
Lordship, page
28th December 2016.
Page
Was that order?
47, Your Lordship,
No,
of
that-
the documents that I had handed over, Your Lordship. The,
Was 28 December.
Your Lordship, page
1970.
47. I had page 47, Your Lordship.
That another bunch.
These are the annexures of the OA, Your Lordship. Page 47.
Page 47. Yes. In reference to your application. How he could have exercised such option? He was not in service. He was terminated.
Your Lordship, that is the reason I was showing page 17 and page 18 of the circular. In the writ petition, page 18 is the options that were renewed. There were in the
Page
list.
18.
Page 18, Your Lordship. Page 17 is the master circular.
The page 8. Page 17. Acha, yes, master circular.
And
yes.
page 18, Your Lordship,
Hmm.
is the options validity period. It was extended 12 times, Your Lordship. During which period?
Page come to.
Page 18, Your Lordship.
It was extended till
12 times, Your Lordship. This tabular chart is there.
So lastly, option validity was up to 30th of September 1990, 87. But at that time he was terminated.
Your Lordship.
Delhi High Court order came subsequent there.
Your Lordship, Delhi High Court order came on 1957. He was reinstated.
73.
Your Lordship. And this is 87. In the list of dates also prepared, I have given that how many times the benefit was renewed and the options were given. Your Lordship, the learned.
So where is that point considered in the tribunal order? Mr.
Paras.
He have not been able to brief him, Your Lordship.
Appreciate, Millard. I am a newly incumbent, Millard. I was not in a position to, Millard, well versed myself.
1 week's time may be granted, Your Lordship.
You tell us why didn't you were reinstated in 1973. You rejoined in 74. Then why didn't you exercise that option?
Kindly once again come to paragraph 6, which I was placing. Tribunal said.
Mr. Deo, we will give you last.
Tribunal said it was the finding of the tribunal.
Para
6. Internal page 12. Impugned order, internal page 12.
Para 6, yes.
Yes. It says tribunal
Not
has
applicable
found
to-
out that circular which my learned friend is referring, that is master circular number 53, that is not applicable. In respect of my case, that is master circular number 54 is
Where
applicable.
is 54? Oh, 54 টাও নেই মামলা করতে চলে এসছো।
I knew, Malad, this would come. I knew.
What he says is right.
Malad,
53.
no, 53 is not applicable. Kindly come to, Malad,
the-
tribunal has quoted this.
You have not seen that circular also. Your junior has
Malad, that has been quoted.
54.
Yes.
Where?
Well, in his rejoinder to the argument put forth by the respondent learned counsel for the applicant has stated that the master circular number 53 is not applicable to the facts and circumstances of the present case and would reiterate that master circular number 54 squarely applies to the applicant's case. Learned counsel for the applicant
They are
would
saying
also.
53 is not applicable.
Yes. They are saying 53 is applicable in my case.
Yes. Now
And my contention is 54, not 53.
Where is 54?
Malad,
That you don't have. So then what did the tribunal say?
Malad, kindly, Malad, come to, it's been
rejoin
quoted, it's been quoted. Malad, kindly come to 201, Railway Pension Manual, just in that paragraph.
01. This is 54.
No, no.
তাহলে?
My lord, the manual has the two.
No, we are not concerned. Manual, we understood clause Roman 2.
Roman 2.
That
I
we
come
understood.
under Roman 2.
No, but what is 54? Where is that discussion that this rejoinder you have stated 53 is not applicable, 54 is applicable.
Yes.
So where is 54? You show us.
Kindly, my lord. Then, my lord, kindly grant me 2 days time, my lord. Relying on.
Judgment. Sir, the only short point is involved.
Only.
That reinstatement by a judicial order. That order is not challenged. So you should be deemed to have been reinstated from that day.
And that service would be.
Acha, wait. Then you should be treated as an employee continuing since 1957. Now, in the midst of that period, as circular comes, says that an in-service person must give an option. Your contention is I am not required to give that option because I was not in service.
And
I came in 19 after the Delhi High Court order. And you rely upon Master Circular 54. 54 you show us. This is the only point. Give a copy to him. You show us, then question of entitlement goes. Unnecessary matters are dragging for 6 years, 7 years. Hardly learned advocates appear.
May I take back the list of dates so that I can come with, because second judge's copy, I could.
This is my list of dates, not his.
না,
This
না,
is
এটা আমার,
আচ্ছা
দেখে নাও।
হ্যাঁ হ্যাঁ তোমার
আমি কি নোট করেছি মুছে দাও।
I got
ওটা থাকুক এখানে আমার কাছে, ওটাই আমারটাই থাকুক তাহলে।
Milord, at the outset, Milord, I apologize for my absence, Milord, on the last day, Milord, for which the proceedings could not be proceeded with. Now, Milord, if I take, Milord,
Mr. Basu, please tell us 2 points. As regards your argument that now it is confirmed that 2006 rules will apply, Rule 61 or something. So far as payment of gratuity is concerned, that has to be subject to the criminal proceeding which is pending. That was one of your submissions. So far as that is concerned, so your next submission was that direction in money cannot be treated as a precedent, that paragraph. Subject to what Mr. Das says, we have seen the text of the order. Our question to you is, so far as the gratuity is concerned, ultimately, if the proceeding goes against him, he will be entitled to gratuity, become entitled rather. But at that time, you will be facing a problem of 7.3a and 7.3a of Gratuity Act, which tells that interest has to be accumulated for unreasonable withholding of gratuity. So, subject to what you say, if we are thinking in this fashion that the gratuity amount you calculate and deposit in a fixed deposit. If he wins, he gets. If he does not win, it gets lost. One. Second is, if he is to be considered only in terms of Rule 61, kindly Mr. Basu go through the provisions of 61, which does not say anything about withholding of pension. Gratuity can be withheld. So, as regards the pensionary benefits, Mr. Basu, subject to what you argue, we have not found, because that Allahabad judgment Mr. Das was relying.
I was not favored with a copy of this judgment. I did not get any chance.
I gave him on the very first day.
When?
Mr. Das,
Very first day. Very first day.
Mr. Dasu, Mr. Basu, just consider this. Consider this. You argued about the central railway service pension rules of 72. We have checked up those provisions. Under the railway service pension rules, there are provisions for withholding of pension. But 61, subject to what you say, does not speak about pension. So we are saying that we will say that his tribunal order will be set aside, because tribunal order last 2 lines says that retirement benefits on the basis of our finding. So we will set aside that order, and we will direct you. We will record that it has now to be under 2006 proceeding, but the persons have retired. You have to either rejuvenate the proceeding or start from the stage where it stopped. That I don't know how much will be feasible. I don't know.
Subject to Milord, what my lord will say.
We are intending to pass this order. We will allow your appeal. We will allow your appeal to that aspect, to the expect that 2006 rules, because that has been said by the Supreme Court. And we will also the paragraphs. We will tell you. Just we are interacting. We have not decided. As regards your argument that this cannot be treated as a precedent, we agree, because that was in the facts of that case. And so far as the pensionary benefits, Mr. Basu, we don't find any provision by which you can withhold.
No, Milord, I bow down to my lord. Milord, with regard to the gratuity, Milord, on the last day I was confronted with a proposition of law, Milord, which your lordship subscribed, to the extent that the gratuity cannot be withheld because it has, Milord, the power to overriding power, Milord, to all other provisions. Now, Milord,
no, that suppose we do not, suppose we accept your submission. Gratuity totally cannot be thrown out of
no.
So
Milord, that is
we are without going into that juxta point, we are saying that gratuity which is payable, you fix that you keep it in a fixed deposit account. There can be no problem.
Number 2, Milord, the commencement of the disciplinary proceeding, Milord, could not be concluded because of Millard the pendency of this proceeding. Because the criminal proceeding, Millard, the retirement, he has already retired. Now, Millard, the central civil service rule. What are they?
That will not apply, Mr. Basu. Because you cannot go beyond the order
Millard,
of.
it applies subject to correction, Millard, that the all salutary corporation and authority, it comes within the clutches of that was also Millard read before your lordships on the last occasion.
That has been dealt with by the Allahabad High Court judge.
Millard, Allahabad High Court was never.
At 57A.
I was not. I was.
Yes. Mr. Basu, that 37A or 57A you stated, na?
Yes. ওটা বার করতে যেটা আগের দিন বলালাম
last.
এইটা কি করে ও দেখে আসবে? What is your, Mr. Basu, you go that?
My contention is that, my lord, if he says it has to be disciplinary proceeding, has to be revived, there is no scope. This judgment, my lord, that Tapan Kumar Das, which they banked upon, my lord, that judgment.
No, Mr. Das.
It is a judgment in personam, my lord, not in name. Lordship will find.
Which one?
Their lordships said that Tapan Kumar Das. Actually, I go back to on 29/4/24, where I was.
Same order, Mr. Das. Identical order. One went to Supreme Court. This is
their lordship will.
BSNL has also preferred.
Their lordships have
you preferred independent SLP against the other two also?
Their lordships have said it shall not be relied upon as a precedent. Doctrine of precedent, or for that matter,
Mr. Das.
And one more thing.
We will give you a judgment. We will give you a judgment. Why we are saying that it cannot be treated as a precedent? Precedent for the reason that was total settlement. That proceedings cannot be continued at this stage. Whatever the admitted dues, you pay and finish off the chapter.
Lordship. That is why I wanted to did not want to go through that.
Exactly. Now, if Mr. Basu agrees to this proposition, we can pass this order.
He says about
gratuity amount will, but this argument which you are making, that today they cannot proceed in terms of 2006 rules. That, Mr. Das, is a bit.
My lord, there also I do have my reservation. I wanted to cut short the matter because he is at the fag end of his life.
In 2013, we had, but.
No, very well, my lord. I can resume my submission that I was continuing on 29/4/2024.
That
right from that I could have continued, but it will take time. Only I am concerned with the gratuity. That is why, to cut short the matter, I say I was.
The pension you are getting.
Pension we are getting.
Oh, then the problem.
Only gratuity.
Total pension or provisional pension?
Provisional pension, that is of course in full. That. Of course, commutation we did not get. Commutation we did not get. Had it been.
Are you getting the full pension or the provisional pension?
Provisional pension, madam. So.
Maniklal is getting provisional in the chart we are seeing.
What we find, this judgment, what we find, that was rendered in absence of the Union of India. Whereas Union of India is the main part.
No, Mr. Das, if you are getting provisional pension, into Rule 61 কোথাও নেই।
Will say, Millard, Rule 69 and Rule 37. Millard, I'm going through the CCS pension rules, Millard.
You take time. You have to go through it. You have to go through.
May I copy that? আমি জেরক্স করে নেব। এটা জজ সাহেবকে দিন।
Actually, after 2 decades,
ফটো তুলে নেব। একটু ফটো তুলে নিন, এক মিনিট। একটু ফটো তুলে নিন।
Otherwise, I have.
May I have the liberty, Millard?
Because suppose after 10 years we pass something, this organization will be paying interest with 18% now. The Gratuity Act now
Yes,
7.3.
yes, that is why, my lord, you are telling me.
You are aware of that.
But this judgment also, your lordship's judgment also, my lord, said
Yes,
that, yes.
we gave on the basis of 7.3 we imposed, we said illegal withholding of gratuity. So to overcome that issue,
yes,
you will only deposit the admitted gratuity amount in a fixed deposit.
And the pension, the provisional pension, my lord, he is getting.
Provisional pension, Mr. Basu, what we are saying, you are already paying 2/3. So what remains is 1/3. That, Mr. Basu, if you are organized, then we can, this declaration will seal the fate of the proceeding, because you also don't know, I also do not know, he also does, when the CBI proceeding will end. Person has to survive, no? And in fact, upon going through Allahabad High Court judgment, because just now you have...
I have handed over. Just now, may I take the photograph of this so that I can...
Yes, take it. And you assist us, because if we are expressing our viewpoint.
You ask your junior to get it copied and give it to us. Okay, you take it and get it copied and then give it.
Deeply obliged. So, may I come back on Monday subject to convenience or Tuesday? Instruction, I want to be armed with a written instruction.
Mr. Das, you also tell us whether you are getting 2/3 of the pension as provisional pension.
I am told he is getting full pension.
Oh,
So it is said provisional.
pension.
Yes, my lord, full pension. So it is said provisional pension.
Then there is no problem.
There is no problem. That is why I wanted to cut short.
Then,
So,
Mr. Basu, we are disposing it of, saying that 2006 rule will apply. On the basis of that, you will proceed.
And tribunal, order of tribunal is set aside.
Judgment will be set aside. And we will say that that portion is cannot be treated as a precedent. That portion cannot be treated as a precedent, but with an intent to safeguard you, quoting the Gratuity Act, you deposit the gratuity amount in a fixed deposit before the registered general.
Then, let it be a court's direction, my lord.
They will not release the gratuity, my lord. No, they will release the gratuity.
We will secure the gratuity.
My lord, the Payment of Gratuity Act.
My lord, it says, my lord, on the last occasion I took, my lord.
That is why I was referring to the earlier disciplinary proceedings that took place for 4 or 5 years.
No, that has gone.
Nobody said no. I said nobody said I have incurred so much loss to the department. They can recover the loss. They can even forfeit it, but they cannot withhold it. That is the crux of the Payment of Gratuity Act 1972. There is no question of withhold is a word unknown to that act below. And
No,
that is the
Mr.
Payment
Das,
Act.
Suppose after 10 years you lose in the criminal proceeding. What will be the outcome?
Criminal court, you will face jail and all these things, criminal punishment.
No.
They cannot.
If you are found guilty in that proceeding, then the Gratuity Act itself will apply against you.
That time they will recover some way or other. There are ample criminal.
Lord, it is a very, my lord, this submission is not, cannot be countenanced.
Payment of gratuity, they are guided by
Whatever.
Payment of Gratuity Act. No, you are guided by Payment of
No, my
Gratuity.
lord, what?
Then you forfeit the entire thing.
There is a question, my lord, today.
No, his argument is Gratuity Act, you can forfeit.
Forfeit.
You can forfeit
Tomorrow,
the gratuity, but you cannot withhold the gratuity.
No, my lord, that is why, my lord, your lordship, my lord,
He has caused, I again repeat, my lord, he has caused not a
so then, my
single
lord,
copper loss.
decide the issue, my lord. Let him
Not
argue,
a
I will argue.
single copper loss to the department.
No, that is not the law.
Yes, what are you saying?
He has not a single copper loss to the department.
No,
Immaterial.
You are
Immaterial.
No.
It is immaterial.
You wait for them.
It is immaterial.
Then
Kindly
wait
seize the
for
language of the
CBI.
statute.
My
I
lord, if
respect
it
his
is for
understanding and
CBI,
perception, my lord.
all
But
this-
I respectfully disagree, my lord. What has fallen from my learned senior friend.
Lordship, what
I respect his perception and understanding. Even then, I respectfully disagree with him. My lord, kindly see, my lord.
Go through your first charge sheet.
No,
just now, don't quarrel with. Because there is no paragraph 19. প্যারাগ্রাফ 15 টায় যদি আসো,
15 আমি এটাই করতে
হোল্ডিং ফুল পেনশনের কোনো প্রভিশন
প্রভিশন
Rule 61. Rule 61, 2006 rules.
2006. Yes, my lord, that is payment of gratuity act.
No, 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 not payment. 2006, they are conduct rules, under which they are proceeding against you.
কোথায় গেল এটা দেখো পিছনে দেখো আছে রুলটা কোথায় PSN is CDA rule 61 page 297. Yes, my lord, I was referring to that.
Kindly come to subclause 3.
Huh.
During the pendency of disciplinary proceedings, the disciplinary authority may withhold the payment of gratuity. For ordering the recovery from gratuity of the whole or part of the pecuniary loss caused to you. Your contention is I have not caused any pecuniary loss.
Subsequently, lordship goes to that payment of gratuity act.
Yes, payment of gratuity does not speak of withholding of gratuity. You are right. And section 14 of gratuity act, superior status is given. But Supreme Court has said that you will be tried under the 2006 rules, which permits the authorities to withhold the gratuity. Why? Because of section 4(6) of the gratuity act, that if it is ultimate.
If this judgment we have to rely on, I do not know whether any other judgment is there. Supreme Court says this cannot be a precedent. Actually, the Supreme Court has exonerated.
Try to consider in this judgment, in 2006 rules will operate. There is no dispute as regards this.
Will operate, my lord.
Will operate.
That is in 58. Lordship comes.
Exactly. That Supreme Court has also said. Now, Rule 61. What is Rule 61? Rule 61 is a disciplinary proceeding provision, which says that you can withhold the gratuity under clause 3. So when this provision is there of withholding of gratuity, we cannot direct them to pay you the entire gratuity, because if after 5 years it is ascertained in the criminal proceeding that you have caused financial loss to the person.
That is not their case, my lord. They say I have.
That is neither our case nor your case, not that is why we are securing. We will ask the BSNL to deposit your entitlement gratuity amount in a fixed deposit, which will be subject to the decision in the criminal proceeding. If you come out If you come out to be
Very
without
well,
any
Lord.
fault, you will get the
It has
gratuity.
fallen from your lordship, so I bow down to that.
No,
But
we
what
can
I want to point out here, my lord, he retired in 2012 April. From 1st May, all the interest payable on gratuity should be accumulated, should be counted with that, and that amount should be fixed.
that is not our, they have not said that they will
No,
be
if
giving.
your lordship says,
is it their case? There is no dispute as regards this. If that is another dispute you are opening. Now we can only tell them that you have to give the entitled gratuity amount, you deposit in a fixed deposit. Quantification has to be done by
gratuity
them.
amount with all interest thereupon.
Interest we will be giving, because once we direct it to be fixed, it will be in a pension bearing, in a interest bearing scheme. So after 10 years, when the criminal proceeding suppose is held in your favor, you get the entire gratuity amount together with the bank interest earned. Unless we pass that order, they will not deposit that gratuity amount.
I was also saying the same thing. I was saying that the amount they will keep it. To
read 65.
Your lordship has perused that.
The 65
They say the service condition of applicant respondent with regard to entitlement for gratuity is governed by PG Act 1972.
Yes, you are right. You are right. But here, the rule which is operating is Rule 61. Supreme Court said that you apply 61, Rule 61 or 2006 rules. In the face of it, can we say that no, that order is not proper, you have to apply as per gratuity in terms of this judgment? That we cannot do.
No, my lord, it has fallen from, I agree to that, my lord. But the point that I am afraid of, whether I am from frying pan to fire or not, because CBI will take time now. They will be going on.
But then you
only one indulgence.
show us, Mr. Das, what other benefit
Lordship can do it. Half of that at least should be.
We cannot ask them.
Of course,
either we ordered, or we cannot ask BSNL be kind enough to do it. That is the part of the legal officer. That is Mr. Basu, if he is a senior person, upon perusal of the records, if he finds it is justified, he will accordingly advise his client.
Difficulty is that he is not kind to my client. That is the thing.
You tell us pension amount, what if you have got full pension, there is no problem with it.
Milord, nowadays, as I'm told, as I know,
permit me to come back on Monday or Tuesday. I want to be armed with a written instruction from my client. AGM legal is there. He said, Milord, the part and the whether he is getting a full pension or not. And with deepest respect to my learned senior friend, 61, which your lordships have pointed out, it is in perimeteria with my lord 69C of the Central Civil Service rules. Nothing has been in a way.
একটু different আছে।
69C.
Please check up.
Not perimeter.
All right.
Not
Milord,
perimeter.
now, Milord. But the question here is, Milord, after the because Supreme Court's order, which my learned senior friend has read, Milord, it has two components. The second part, Milord, the exonerating the gentleman, Milord, 1 lakh, 2 lakh fine, Milord, that was in the conspectus of fact that he was not Milord, entangled with the criminal case, or there was no pending. Here, Milord, the Gratuity Act, your lordship relied on Milord 2013 3 SCC, on which Milord your lordship had subsequently passed a judgment. Now, Milord, this paragraph 15 and 22, it is in no uncertain terms said, Milord, that under what circumstances you can do it. Gratuity Act says, Milord, discourteous service also. It says it is not only a conviction, Milord. It is a question, Milord. It is a case, Milord, where a government.
No, you are not required to advance that argument, Mr. Basu, because Rule 61 of your 2061,
yes, it settles.
Has been directed to be applicable by the
Supreme Court. Matter ends.
Which has been, we understand your
I'm
argument.
sorry, Milord.
2006 rules have been, Supreme Court has said that will be applicable.
Yes.
We cannot reinterpret the Supreme Court order.
I'm extremely grateful.
1961 rules permits you to withhold gratuity.
Right.
But the thing is, this amount has to be secured, because otherwise, if after 10 years, if he come out with, if he is clean, then you will be under an obligation to give him the entire amount along.
I will be saddled with, Milord, very high amount, astronomical amount of interest, Milord, and I've got public money.
Yes, that will be public.
Yes. Milord, that is why, Milord, I sought for instruction, Milord.
You
Kindly
take
protect.
a written instruction to that effect, and you also tell us, as our officer, please tell us whether pension amount, whether he is getting full pension or 2/3 pension or how.
Yes, absolutely.
This one. And what my brother wants to speak out is this 2000, from the date of his retirement till today, he has not got gratuity. So this period will also carry interest. This period will also carry interest. So you have to deposit the entire gratuity amount together with interest pertaining to
accrued thereupon till date, from the date of retirement.
Pertaining to that, because that in a fixed deposit. That will come with that instruction, we dispose of.
And Lordship may direct CBI to
expedite the proceeding. Yes, we will.
And Lordship may fix it date also. Time also. Now it is two decades past. Lordship's order will be binding on them, whoever they may be.
Mr. Das, once done, once done. We will not even. Just tell us, Mr.
Yes,
Basu, we have extensively, we want to finish it off.
Milord,
All the three matters.
Yes. Milord,
There are three matters.
yes,
na?
11.
One is of Maniklal, আরেকটা যে রতন কৃষ্ণ, and
আপনি
then
রতন তো?
সুব্রত গঙ্গোপাধ্যায়।
আপনি রতন?
আর ওদেরটা
Milord, my learned senior friend is representing BSNL in one matter.
So you can always consult with Mr. Basu. He's also in their matter. We are not saying anything unreasonable. We are saying reasonable. Maniklal-টা তো
There are also gratuities with
Maniklal-টা কত নম্বর হবে?
And incidentally, the third matter also I did it before the learned tribunal.
So, Mr. Basu,
only one difficulty, Milord. The telecommunication, Milord, the gratuity will be released by the Telecommunication Union of India. The department, that is my IGM legal says, Milord. We do not have any difficulty, Milord, so far as this.
No, why you are dragging them? You are being tried under 2006 rules. Responsibility is upon you, because you said DOT is not concerned.
The passes order, they will pay.
Yeah, Mr. Basu, please don't create that confusion.
The sanctioning authority is, Milord, the central government.
No,
kindly, Milord.
We will pass a mandatory order towards that. It will be binding upon all.
Lordship.
So if BSNL wants anything from any input from the government, it is for BSNL to obtain that.
But Milord, kindly have the charity to consider that I want that the court's order should be implemented in its true sense and within a specific time. As an officer of the court, my lord, only for this, my lord, in order to facilitate this process, my lord, I make this respectful submission before the highest court of the state. Kindly also, my lord, direct the central government that they must play their role, my lord, in order to secure compliance of your lord.
We want our order to be implemented.
Right.
What you are saying, you apply your good office, Mr. Basu.
No, I will, my lord, but I am not representing the Union of India, the sanctioning authority. Only to that extent. Similar items.
Have you, Mr. You are also there, Mr. Mundi?
That is also gratuity with it, my lord.
Gratuity, we have told what we are wanting to do. You have heard it. So you also ascertain.
I got your lordship's fine. 11th, 2 p.m. Milord, subject to convenience. 11th, 2 p.m. Milord, subject to convenience.
You are coming with a chart in respect of the three persons. How much pension they are obtaining. If they are getting full pension, no problem will that. We will say that will continue to be paid. They will also take instruction how much they are paying.
I will. I will go.
Bring the PPO. Mr. Bose asked them to bring with the copy of PPO, pension payment order. You also bring your PPO.
I will get it. I will get it.
It will say everything. Huh?
Actually, my client is bedridden. That is why I cannot always get the instruction.
No escape route. ওনারটা ফুল
11 তারিখ মানে তো সামনের সোমবার।
My lord, I beg to appear for the petitioner in this matter.
I am for Union of India.
12 আপনি নেই।
Only in 13.
Eh?
In 13, I am for Union of India.
My lord, 13 and 14 I am appearing for the railways, my lord.
12 to 14.
My lord, land losers matter, my lord. So already has been fixed, all these three matters, my lord. Already that may be fixed.
My lord, actually, earlier your lordship was pleased to hold that all these matters will be taken up on the last 30th, but the matters didn't come on that day. 30th of last month, 30th July.
We changed that date.
Oh,
We
date
said,
was my lord, kindly you tag with the other matters, my lord. It
Your
will be
lordship,
heard.
155 are the serial numbers which are again land losers matters.
10, 11, you are this is
12 to 14, my lord.
12 to 14 is also land losers, and 155 to 163.
12 to 14, 155 to 163.
Your lordship. They have been clubbed together. 155 to 163 have been already clubbed together.
Which one?
So very good. You do this, then we have reached now.
My lord, all the other matters are fixed on other.
We cannot call everybody to come and appear. If they don't appear, what can
Mr. Shobhik Ganguly has already started.
Shobhik Nandi had started. He had made
arguing on the matter,
compilation.
my lord.
It was on Saturday
So,
the
my lord,
matter had
there will be
appeared.
different arguments that will be coming, my lord. Let him take the lead and do the matters, my lord. Similar issues involved in all the matters, my lord.
The other matter which was on Saturday has not come up in today's list, which was there on Saturday. Kaushik Hui, which is a leading matter wherein Mr. Shobhik Nandi was arguing the matter.
Which one?
Kaushik Hui, that was on Saturday's list.
বের করো তো Saturday list.
Kindly here's the matter today.
What different? It is not land loser.
Land losers matter, but there are certain disputes. They have alleged, respondents have alleged that he has submitted a fraudulent document. After the affidavit is served upon me, I have tried to reach the petitioner several times, but he didn't receive my phone calls.
21.
So,
what do you want?
My lord, the matter may be dropped.
WP number?
Oh, you don't want to proceed with the matter.
My lord, actually, he has submitted a false pass certificate of Madhyamik examination.
You consider, we do not want to embarrass you. If you said that you want to withdraw, you withdraw.
My lord, I want to withdraw the matter.
In
terms of item 12, my lord.
Instructions. Your lordship, he has no instructions today.
My lord,
do you know who is the writ petitioner? 155 to 164.
Several other advocates who are appearing. One day your lordship has given to these.
My lord, in this we matter, Mr. Ochinto Banerjee was appearing. We. Kaushik we matter, Mr. Ochinto Banerjee was appearing for this.
Note করে নাও তন্ময়।
My lord, I have before the petitioner this matter, my lord. My lord, pursuant to lordship direction, my lord, we have already served, my lord, to the respondent concerned, my lord. This is the, my lord.
Where is your affidavit of service?
Affidavit of service is there, my lord. I can find.
We don't
Affidavit
work
of service.
in
Yes,
this
yes, my lord.
manner.
It's there, my lord. I will. My lord, this is. इम्प्यून ऑर्डर दिखा देते हैं पहले, हाँ? है ना? March, my lord. 2023, my lord. Basically, my lord, this order was passed in the MA, my lord, filed by the petitioner here in, my lord, for modification of the order, my lord.
So first show us the order of 30th November 2017.
P1, my lord.
That one you wanted modification, na?
Yes, I have prayed for
So
modification.
30th November 2017 order is at which page?
Page. Just a minute. My lord, that's page 34. It is okay.
Is 34.
25. 34 se to.
34 is not telling. It is the
Yes.
WPCT number.
24.
My lord,
You are saying.
kindly give him, my lord. My lord, kindly give him. It's, my lord, page 25, my lord, annexure P1, my lord. That's the first order, my lord. That's, my lord, the order.
Just a moment.
Yes. हम लोग बोले नहीं बोले थे फाइनल करने के लिए ना
By accepting the clear made by the land council proposed survey but to publish the final list of result candidates in place with the reputation. Again, this is the crux. According to the land council proposed, you will be satisfied with this. अभी तो रिजर्व कैंडिडेट से लिए हम लोगों को कोई गुरफांस नहीं है
बस एससी वाला
कल ओनली एक पोस्ट कर ली
that is SC candidate.
They have not published the final list of reserve candidate, that is the SC candidates.
हम लोग कंप्लाई करना चाहते हैं.
हाँ, SC candidates, only one post. यहाँ पर भी लिख दिया था that council for the response has no objection to such a हम लोग RPF we want segregation. My lord, today we are not at all yes.
पेज नंबर लिखा हुआ है कंफर्टेबल.
ये सब बड़ी बेकार नहीं अपना इतना दिखाना जरूरत नहीं ओनली मतलब वी नीड यू वांट पूछ लेगा हाँ कर दो हाँ बढ़िया गुड
Application.
Yes, my lord.
How that is maintained?
My lord, today, my lord, I am not harping on that. Only the point is, my lord, regarding segregation of the, my lord, segregation between the RPF and non-RPF, my lord, scheduled caste, my lord, my lord, the respondent here in, my lord, happened to be a, my lord, happened to be a, my lord, best among the failed candidates. There were 36.
He is of reserved category.
Yes.
Applicant is of SC.
SC.
Yes.
One post is there.
Directed that so far as unreserved vacancies are concerned, you declared the result.
Yes. Only, my lord, today.
On the basis of consent given by the parties.
My lord, we are not.
What did the tribunal did?
My lord,
he said that reserved category candidates be published. Finally, sir, then how you are agreed by?
No, my lord, we are not on that. Only we want, my lord, there is a one post left. One post scheduled caste, SC, one post left, not there are 36 candidates. Whether, my lord,
we want today segregation, because there is a circular of the
Segregation of what?
RPF and non-RPF, my lord. Whether the RPF candidate can be included in the selection process or not, my lord.
So do it, who is stopping him?
No, my lord, but lordship candidate, because there are, my lord, RPF, we cannot include RPF. There are 6 candidates, my lord, in that category. We don't want, but
No, there is a there was an unreserved category and there was a reserved category.
Yes, my lord.
On the basis of the selection process held pursuant to the advertisement of that 8th of some advertisement date was there.
Advertisement date was there, my lord.
So you withheld the publication of the entire list, reserved as well as unreserved. Ultimately, court by the order of that origin said that unreserved is to publish.
Yes.
So now why you are coming with that order has been upheld in by the
tribunal, by this honorable court. But my lord, we want to why we want segregation, my lord. That's page 46 and 47. Your lordship context, my lord. 46, my lord. That's a
segregation for
circular.
what? We don't understand.
My lord, kindly 6, my lord. Page 46, my lord.
46. Yes.
45. Oh, you also there, my lord.
Make up your mind.
Page
45
45,
or 46?
page 45, 46, 47, my lord. Your lordship, can you take note? This is, my lord, this is the circular, my lord, dated 21st August 2015, my lord.
Yes.
If your lordship kindly comes to, my lord, in continuation, second, my lord, my lord, first paragraph, my lord, in continuation to this office notification dated 18/6/2015 under reference, the vacancy position of the subject selection stands modified as under. So, my lord, vacancy position, my lord, 7. This is a common breakup, that is, my lord, under you are, my lord, 6 SC1. Your lordship got, my lord. Here we have no grievance, my lord. Everything has happened. Only, my lord, as modified. Lordship kindly comes to the next paragraph, next column, my lord. That is 8. My lord, the communal breakup. You are 7 SC1. Here it is, my lord. We are something is troubling us, my lord. Here with regard to SC1. My lord, here, my lord, if your lordship kindly takes, my lord, there page 5, my lord, of the writ petition. Here we have already given, my lord. My lord, the non-RPF, my lord, page 5, my lord. Clause B. Written test was held on, my lord, 24th August, 24th January 2016, and confidential report and service record.
Where you
Page 5, my lord, of the writ petition. Lordship got it, my lord?
Written test was held on such and
Yes, and confidential report and service record were shot for on 5th of April 2016 for the written qualified candidates for further assessment of marks as per the standard selection procedure. Details breakup of written qualified candidates, including best among the failed SC candidates. My lord, here lots of candidates, this is very important, my lord, including best among the failed Supreme Court, sorry, my lord, the SC candidates, my lord, is given here in below. So, my lord, here non-RPF is 4. We are not at the RPF 6 and non-RPF 36. There is a circular that we cannot, my lord, include RPF in this process, my lord, because we want to, my lord, finalize, my lord, amongst 36.
To do it, where is the bar?
But, my lord, your lordship, and there is trouble, my lord, in the MA application, my lord, which we have filed, my lord, the order came, my lord, on 31st of March 2023. That's, my lord, 140 of the writ petition. If your lordship kindly comes to, my lord, last page. Okay.
Ordered impugned.
1 to 1. No.
Ordered impugned.
Yes. Page 1 to. Your lordship can take, my lord, this.
31st of March 2023.
Yes, last election, my lord.
কি বলে না বলে বুঝতে পারি না।
31st of March 2023.
No, no, you are wanting segregation of RPF and non-RPF.
Non-RPF.
So why should we say that? What is the order passed by page 25? Kindly come.
Page 25.
The original order passed by the tribunal. Kindly come to page 26, last paragraph. By accepting the prayer made by the learned counsel from both sides to publish the final list of reserved candidates pursuant to the advert within a period of 8 weeks. Only the reserved candidates were directed to be published.
Yes.
So what modification you want of this?
My lord, here, my lord,
show your modification.
What has happened, my lord?
we have never given consent to dispose of the original application, my lord.
Then you should have got
That modification application was filed by the respondents.
What you wanted in that modification?
In that we
This is the modification application.
my lord, this is modification application.
Modification application is in which page?
Page, my lord. Yeah. My lord, today I've got the brief, my lord. That's why, my lord, I'm just coming.
This is no excuse, Mr.
Today, my lord, today I've received
I
this
see
brief, my lord, just because this.
Shah, you are there?
Yes, my lord, I'm just, my lord. Yes, Mr. Shah was there. I'm just coming, my lord.
Your
Application लगाए हैं.
Application for modification or variation. This is of WPCT.
application 28.
Page 28, my lord.
আমিও একটা order pass করেছি।
My lord, 29, my lord, your lordship, can page 29, my lord. Running page 29, my lord. This is our MA application, my lord.
EMA application.
My lord, here the prayer portion
Which
is there.
page?
My lord, page 29, my lord.
Page 29.
9 of the writ petition, my lord, running page 29, my lord. Your lordship kindly says, my lord, here what we have prayed, my lord, that the opposite party herein filed.
Just a minute. Page 29. Page 29. Modification application. Achha. This is your modification.
Modification, the prayer I have quoted, my lord.
পড়ে নি তাহলে।
कहाँ पे बोले हैं देखिए तो
modify the order and pass an order after modifying the order. প্রেয়ার কি সুন্দর প্রেয়ার করেছে দেখো।
This is my whole process will go. My lord, I have come here, my lord, before you for your lordship's clarification and or guidance. My lord, two things, my lord, clarification and your lordship's guidance, my lord. That, my lord, we want to finalize everything, my lord, but we need, my lord, something, some clarification from your lordship's, my lord. I know.
Actually, we have understood that you initiated a selection process for filling up 7 posts of staff and welfare inspector, Mr. Prasad.
Yes, ma'am.
It is admitted position. 7 posts of staff and welfare inspector. Now you conducted written test. Some personnel, some candidate emerged to be successful.
Nobody had passed the written qualifying marks, my lord. Among the best among the failed candidates, my lord, one of the, my lord, the candidates was that the respondent. He has, my lord, filed an OA before the tribunal, my lord.
The respondent in WPCT 267 of 2016, they emerged to be successful.
Yes, yes.
Then subsequently you decided no RPF or RPSF shall be included.
Just because on the basis of the circulars, my lord, of the
selection process shall be limited to the in-service candidate, departmental process one. Now the court says, and hence you cancel the entire selection process.
Yes, previously it was cancelled, my lord.
Cancelled. But those who are successful, they preferred way 818, challenging the order passed in, you file writ petition 267, then ultimately it was all you finalize.
Correct. My lord.
Now you finalize the process in respect of those 4 undeserved category candidates only, but in respect of others.
That's similar in respect of, my lord, 36, which I have shown your lordship at page 5. page 5, my lord. That's why, my lord, we want to fill up, my lord, this also, my lord, that is only one post remains, my lord, SC, one post. And there are 36 candidates. Amongst 36, my lord, candidates, my lord, we want to, my lord, complete this because we cannot include RPF. That is 6 candidates, my lord. For the region, there are circulars of the which has been upheld by the Supreme Court as well as this tribunal also, which is at page
So
100.
that go and explain in contempt.
My lord, there is,
Publish
my lord,
the-
100, 500, 106, my lord. In the other case, my lord, in an identical nature of cases, my lord, it has been done. 105 and 106, my lord. Your lordship can take, my lord. 105, 106, my lord. That your lordship get it, my lord. Okay?
You are,
105.
you are unable to, it is not to speak the truth, it is not, still it is not clear to us. What you want?
We want some clarification. No, my lord, we want some clarification and or guidance from your lordship. That's why my client has come up before.
Write it down what clarification you want.
Clarification that whether RPF to be included in that selection process, my lord, written test is over.
Mr. Prasad, RPF included or not included, it is your headache. Tribunal has passed an order. Passed an order that so far as unreserved list is concerned, you publish. Nothing was said about reserved list. Now you are saying that unreserved list we have published, but you have published the reserved list. You have not published the reverse list. So was there any direction upon you?
No.
By the order, what is the tribunal order? That by accepting the prayer, we direct the registrar to publish the final list of reserved categories.
Reserved categories.
You are saying, so far as reserved candidates are concerned, there are some RPF and some non-RPF. We cannot include the RPF into it. We will publish the list only in respect of non-RPF.
Non-RPF.
So you do it. Who is preventing you?
That is only, my lord, your lordship can passes the order.
What order we will pass? That order is there.
Only that, yes, you go ahead with the in accordance with law. Because, my lord, in MA application, that has not been clarified. But, my lord, in another case, my lord, in an identical nature, my lord, 105, 106, my lord, I want to show you. There, my lord, it has been, segregation part was done. Yes, my lord, kindly say.
Your MA application.
105, my lord, kindly says, my lord, for a moment, my lord. My lord, 112, my lord. My lord, kindly says, my lord, it starts from 105. Your lordship, straightway, lordship kindly comes to, my lord, page 112, my lord. Okay. Yes, my lord. Page 112, my lord, running page. In another case, my lord, it has been done by the tribunal, but in this case, not, my lord. So, my lord, it is learned that the RPF personnel who have been so segregated have not been agitated against the order passed in OA 818, my lord, of 2016. That is their segregation. In the aforesaid background, we allow the present selection for CLA. That was post was different, my lord. CLA to be concluded logically in accordance with law, segregating the RPF from the written test result, and after publishing a fresh written test result, conducting viva voce, etc., as are required to be conducted in terms of the prescribed selection procedure. The entire exercise to be completed with only this much. Only we want segregation.
Okay, we are trying to understand. Yes. Then the reserved candidate also filed 2 original applications.
Yes.
90, you tell the number 90.
That was disposed of.
999.
Yes, no, 2.
Of 2017. And another is?
999?
No. What is 902 and 903? Who filed this?
Some candidates similar to
902 and 903 was filed by
902, 903. कौन है? 8 to 9.
একটা ছিল তো ওয়ে 818
আবার একটা দেখুন WPCT 75 and 76 and সেটা said the order passed in 98. 902 and 903 would be hard affixed by the learned tribunal
and disposed of within a period of 6 months from date.
That has been disposed of.
That has been disposed.
Who filed 902 and 903?
That is, my lord, we have to take instruction.
Yes.
That we have to take instruction, my lord. That is, my lord, Milord, long back it has been in the year 2016 and 17, Milord. All these applications were filed, Milord, and were disposed of, Milord. Long back. So, Milord,
First, you will not annex all the orders. Have you annexed 818 order? OA 818?
818.
Huh?
818 এর অর্ডারের
এটা রিট্রিশন গেল পুরোটা।
देखिए तो
100 पेज में हाई कोर्ट का ऑर्डर है 818 का डेलीवरी।
My lord, your lordship
That is
can
your
get the
modification application.
reflection of that, my lord, in the High Court's order, my lord, which is at page 100.
Your modification application is at page 29, na?
29. तो मैंने आप कॉन्फ्रेंस की जरूरत पड़ती है इसमें मैं no सब है. My lord, all those orders are there, my lord.
Wait.
Page 68. All three.
Oh, 902 and 903 filed by RPF or RPSF personnel.
Yes.
Who also selected.
Yes. Appu Das Gupta.
Yes, who also selected.
Yes.
They also pursuing a litigation that you cannot cancel their participation and their selection. So one parallel litigation is coming. Now the court founds that 4 undeserved candidates who are successful, they are neither they are RPF personnel nor RPSF personnel, and hence court directed finalize and give them appointment.
Today, the only crux of the matter is, my lord, only one.
In this way, we shall
yes.
unearth the fact.
Yes. One post and 36 candidates plus 6 which cannot be included, my lord. We want segregation and guidance from your lordship. Only this much.
Now, what about the reserved candidates?
Reserved candidates.
Reserved candidate says that since certain RPF personnel participated, you cannot cancel the inter-selection process.
Yes.
So what is the original application of reserved candidate?
Your lordship would get, my lord, the order. My lord, 979, my lord. That's the operative portion, my lord. Clause 10, accordingly, the impugned order of cancellation dated 23/5/16 of selection process for recruitment of a staff and welfare inspector in PB2 with grade pay such and such, my lord, for headquarters unit, and further selection notice issued by the respondents for recruitment of the same posts are hereby set aside. The respondents are directed to proceed further to finalize the panel for appointment to the post of staff and a welfare inspector in accordance with the recruitment rules forthwith in pursuance of selection process initiated against a notification dated 18/6/15. The whole exercise should be completed by the respondent within 3 months from the date of production of the certified copy. Now, your lords.
পড়ে আসতে ভালো করে বানিয়ে নিয়ে আসা।
वो 7 वाला क्या हुआ? 7 तो खत्म हो गया, उन लोग को मिल गया। 7-8 पोस्ट था ना, 7 को तो कंप्लीट कर दिया, 1 तो था, तो ये 7 का उसके में कोई डिस्प्यूट नहीं ना है।
ওদের মূল গল্পটা হচ্ছে Para E or prayer? Para F of this order.
प्रॉब्लम अब नहीं ना है, अभी खाली यही प्रॉब्लम एक ही है।
रिजर्व को लेके इसलिए प्रॉब्लम नहीं है क्योंकि वहाँ पे आरपीएफ लोग कोई क्वालिफाई ही नहीं हुआ है
हम लोग
उस पोस्ट में कोई
7 को वाला
অসুনিয়ানব্বইটা আবার কে ফাইল করলো?
99 এইটাই রিজার্ভ ডেট
ও
যে নতুন
আচ্ছা,
পেজ
আচ্ছা,
25
হ্যাঁ 999
CLA, my lord. Supreme at 130, kindly allow me, my lord, to place this, my lord. My lord, page 137, my lord. In a similar case, in a
Confused once again.
my lord, I'm just placing this paragraph, my lord. Kindly says, my lord, same thing which I'm asking for, my lord. Lordship kindly says, my lord. I'm praying for this, my lord. Lordship kindly, it has been held, my lord. Page 137, running page, my lord. This is the, my lord, the.
Okay, we have got the facts at last to some extent. You initiated selection process, excuse repetition, for filling up 7 posts. Okay. Subsequently, you took decision that no RPF of RPSF personnel should be allowed to or should be chosen for the said post after conducting the written test. Now, 4 candidates belonging to undeserved category, they initially came before the tribunal, then before this court, stating that we have been emerged to be a successful, but they are not publishing our result. Ask them to direct them to publish the result. Honorable High Court says that publish the result in respect of 4 undeserved candidates. Then you publish. Then subsequently, undeserved candidate, they filed an original application 999. Stated that in similar line, you also give a direction to publish final list of reserved candidates. Your counsel before the tribunal said, I have no objection if this direction is given. Accordingly, court directed. Now you are claiming that no such concession was given to the learned advocate. Concession was given for the disposal of the original application, not for publication of the result. Now it is your stand.
How does it bother you? Because court has directed by the order which you are seeking modification that publish the final list of reserved candidates. You are contending that this, you add one line there that is excluding the RPF personnels or RPF personnels from the said selection process. That is your contention. So you yourself exclude and publish the list. Now, if the contempt application comes, you explain this.
Yes.
Finished.
Yes.
The present writ petition has been preferred.
My lord, directed to serve them because this is probably the third or fourth time that they are not appearing. Service হয়েছে তো? শুধু দেখাচ্ছি। Delivered to. Delivered. Lordship can see. Very short point is for the compassionate appointment, whether for a compassionate appointment,
Compassionate appointment.
whether the benefit received by the deceased employee will be considered or not considered. Initially, it was the law that it will be not considered. We have to see as if nothing received, what is the hardship on the family. But slowly, the law modified from Canara Bank till date, by 2019, that no, we have to see what is the hardship. And in the hardship also, we have to see how much money he has received. If he has received sufficient money, then hardship will not remain. So, compassionate appointment cannot be given. But here what happened, probably the old concept of law has been applied. I am for the BSNL. And then the court has taken a view that no, you cannot take into consideration the benefit which he has received.
Any contempt application filed in the original application, then they are not interested or what?
Lordship?
The petitioner is not interested.
No, probably not, because after receiving that money,
court says what was the without taking into consideration the pensionary and terminal is received.
Yes.
So you show us your scheme.
Yes, Lordship.
You are directed to reconsider.
Yes.
Without being influenced and without taking into consideration that pensionary and terminal benefit shall not be taken into consideration for the grant of consideration of compensation. This is the issue. Yes. So you show your scheme.
Lordship.
BSNL scheme.
My scheme is already, they have discussed my scheme as well.
Where is your scheme, Mr. Banerjee?
Lordship.
Page 83.
Lordship. Yes, Lordship. It starts from page 83 and the relevant page will be 85, Lordship. Circular. This is my 2000 circular. If your Lordship.
Just. একটু আসছিল নাকি
But the order will remain on me.
তিনটে জাজমেন্ট দিয়ে করেছে
Canara Bank.
Yes, that's what page 102.
Proposition is that
102.
Since the respondent's family is getting family pension and also obtain the terminal benefit,
yes,
in our view is of no consequence in considering the application for compassionate approach.
Yes, that is page 102.
Payment receipt of family pension will not disentitle them to get family pension. It is 2015.
Canara Bank 2015.
Relied upon two decisions.
Yes, Lordship.
Govindo Prakash Verma.
Yes, that is 2005 decision.
Balbir Kaur.
Yes. Now, if your Lordship kindly turn to now the latest judgment of 2019, where Canara Bank also has been this, because compassionate appointment in a public employment is an exceptional rule. So, if someone has received certain amount of money by which the family can survive, then also then exceptional rule will be applicable. That has to be seen. We cannot. Suppose someone has received.
The latest
Latest is, Lordship, I am little handicapped. I have not taken a printout. 2019 4 SCC.
2019
4 SCC. Page 285. I'm little handicapped, Lordship. I will.
What is the-
keep it tomorrow? I will give it that.
what is the proposition?
Lordship, proposition is if one of the family member is either employed or receive money, in that case, compassionate appointment can be. Means we have to see the hardship as a seculated from all other issues. But if the hardship is there, but still your received pension is there, benefits are there, then how the hardship will there? Hardship is what? As a whole, the widow, along with the children, is unable to feed himself or herself. Either the case. The widow cannot feed herself, or if I am a widower, then I cannot feed myself. So then, Lordship, if I have got a sufficient pension, pension is coming from my company, my organization only. And Lordship, for your 102, if your Lordship kindly takes the Canara Bank matter, that also I am ready to distinguish. If
No,
your
no,
Lordship,
there was a previous High Court order in this case.
Yes, yes.
So show us that.
Lordship, I have.
What was your first rejection?
Yes, Lordship.
Your first rejection was
no. If your
affirmed by
Lordship
the
kindly,
tribunal.
if your Lordship kindly come to the page 90, if we go sequentially, Lordship.
Page
90, 90. Lordship has seen my employment scheme.
No, no, no. You, what is the fact? Did they come to paragraph 6.3? Honorable Catena, the head compensation after considering the said dicta, practice of negative points, such and such. Directed to consider in consonance with DOPTs and Telecom Ministry. Said order was upheld by the High Court on 8 June. Show us that 8 June order. So you can proceed only on the basis of the parameter described in 8th June order. Where is that 8th June order?
Page 98.
Page 9. Point system introduce করেছে। You have adopted a scheme or policy. Whether there is any prescription, how you will assess the financial condition of the family.
Yes, Lordship. Lordship, yes, Lordship.
Take us to
page 83. That's what I said. Page 83 and relevant will be page 85.
Page 83.
I have a weightage point, Lordship. How I will consider, because if I don't keep a consider in a black and white manner, then the discretion of the officers will come. So, Lordship, page 85, if your Lordship kindly come. Lordship, how much point I am giving, Lordship, kindly see, dependent of the dependent's weightage. 5 point par dependent, 5 point par handicap dependent, 5 point minor, 5 point par unmarried daughter.
It is how much percentage you will reserve, but weightage point system.
Yes.
Now, weightage point system.
So this is
you show that you are entitled to take into account the family pension or other benefits, to take into account to assess the financial condition of the family.
Yes. Lordship, kindly come to page 86 bottom.
86. Yes.
Assessment criteria. Cases with 55 or more, net point shall be prima facie treated as eligible for consideration by the corporate office high power committee for compassionate appointment, ground of compassionate appointment. 2. Cases with net point below 55 shall be treated as a non-indigent and rejected. Lordship has got it. And how this point will be given to 86 bottom, Lordship. Lordship, 86. Page 86, bottom. Lordship has got it.
Yes.
Lordship, this is the methodology how the marks will be given. And if the marks is below 50 case with 55 or more.
But this where is this weightage point taking into consideration?
That is the next page, Lordship. I will take your Lordship.
Yes. Sure.
So according to page 85 and 86, we have to calculate the point. And then the cutoff marks is 55 or above 55. Now kindly come to the next page, page 87, where I have given marks.
You have given 7 points for terminal benefits.
Yes.
Now, where is the scheme which says that 5 point, giving this point, you have to take terminal benefits into consideration? This is the pro forma in page 87 you are showing. Where is the original scheme? This is annexure 1, page 85, which you are showing.
Yes.
Then the scheme must have been starting from
page 83, Lordship.
So 83, where show us that weightage point has to be given, taking into consideration the.
Yes, Lordship. If your Lordship kindly see 4, page 84, 4.
Yes, shall consider application as per weightage point in the case with net points 55. Minutes of this Herkel HC will be sent to BSNL. In case of, where is that? Below 50, a family will be treated as not living in indigent condition. Now problem arose. Now kindly come to the original application order. Page 91.
Page 91. Yes, madam.
Paragraph 4, middle portion. Whereupon case of applicant was considered by BSNL by awarding points on different components as per circular of 27th June 2007. Now, is this 27 June 2007?
Yes, Lordship.
Yes. Now, and rejected, being dissatisfied with the system of awarding marks, the applicants challenge the impugned item 4, which you showed us.
Yes.
The terminal benefits, item 4. No, item 4 is Y for others. Namely, weightage point for assessment of indigent condition. Very good. Next para. Council would draw our attention to item 4. It contemplates 15 points for widow seeking employment. His content then she would get 15 additional points, whereas when the widow seeks for her
This
son.
4 is of page 85. That means who is getting CGA and others who are not getting CGA.
Okay, let us see now. The point of consideration is as to whether item 4, mane applicant's weightage, enabling the authority to add 15 points. He was not given 15 points. He was given nil. Who applied? The widow applied or widow applied?
Is agreed by that. 4 clause 4. That if we withdraw apply for compassionate appointment, he will get 50 points, 15.
And you have given
but if
nil.
non apply, he will get 0. Come to
yes, page 85.
85
for 4.
4.
So when the widow is applying,
he is now 92. He is saying he is aggrieved by that.
Now, Lordship, kindly see.
It was the case of the petitioner.
So, Lordship, now what is happening? If Lordship, that means higher the number, he is not eligible.
It is not their case.
Another, if the widow herself wants to get appointment of the kind, she would get 15 additional point, whereas the widow seeking her son appointment will get ground that 15 point would not be available. This is disparity and discrimination to the bereaved family members. According to he would pray for striking down of the said clause. Par contra, the such and such said such and such committee into account to get an appointment. The learned counsel for would stress upon the point by pointing out that the such avoiding 15 point additional to the widow when the aspire is to get this on the ground is unconstitutional and same facility is not provided on this. Then Lordship kindly come to the page 93, para 8. The contention of the learned counsel for the applicant that if a daughter's son deceased of an employee applies for the employment, he would not be given 15 points. he would not get 15 points, and whether the video of the deceased apply for such appointment on the competition ground, he will give in 15 points, and thereby that the BSNL consider the aspect of the consultant such and such at the relevant point. So Lordship then
now final order হলো page 100 এইটা এবার চ্যালেঞ্জ করলো issued by DOPT your case for family pension টা নিয়েছে terminal benefits 3 লক্ষ both the sons in the have grown up and become major applicant has
then Lordship we preferred to High Court. High Court said nothing doing. Then Lordship page 100. In compliance of the High Court order, we have said so. The BSNL is following the scheme, Lordship. This was
the
sorry, man.
কিন্তু ট্রাইব্যুনাল এখানে কেন ঝট করে বললো যে তুমি টার্মিনাল বেনিফিটসটা কনসিডার করতে পারো এটা কোত্থেকে উনি এলেন
Your Lordship kindly turn to page 100 and 101.
Considers the point that both the
Lordship, we have tried to justify that thing at page 101.
examine the case.
The reasoned order.
So terminal pension received by for the corporation is also it has been watered down. Bulbir courtটা watered down হয়ে গেছে এখন তোমার ডিপেন্ডেন্সি করতে গেলে তোমার স্কিম অনুযায়ী টার্মিনাল বেনিফিটসে যদি স্কিমের জন্য ওয়েটেজ পয়েন্ট দেওয়া without taking into
Para 9. Para 9 বের করো আমাদের marking থাকে।
Court cannot rewrite the scheme.
In all the matters of compassionate appointment, it must be noticed that it is basically a way out for the family which is financially in difficulties on account of the death of the bread earner. It is not an avenue for a regular employment as such. This is a fact and exception to the provision under.
There was no reason 15 marks was keeping in mind video camera. We don't mind. এইখানেও পয়েন্টটাই নিল না।
Yes, yes.
এখানেও পয়েন্টটা নিল না, ডিসমিস করে দিল এই বলে ওই ডিওপিটি কে বলেছে ডিওপিটির ওরকম কোনো সার্কুলার নেই।
Yes, Lordship, this 2014 we have checked it. 2014 is relied in 2019, which I was saying. 2005 judgment based on which the order was passed is no more a good law standing in the field.
No, Canara Bank was the submission.
Canara Bank is not submission. If your Lordship kindly see the impugned order, the impugned order is not passed on Canara Bank. Had it been Canara Bank, then I can also distinguish Canara Bank. Impugned order is passed on LIC, 2005. If your Lordship kindly see the impugned order.
Where from did the court get this? This was not argued, na? On perusal speaking order, it appears respondents have taken into consideration, which is not permissible as laid down in Canara Bank.
And Canara Bank has relied on State Bank.
There is a quarrel in accepting this proposal.
Request করে দাও তুমি।
526 is all army matters, Your Lordship.
Uh-huh.
Army. Disability pension matters.
This is not
Disability.
this is a WPCT, my lord. This is a disciplinary proceedings matter.
দেখি ফাইলটা বের করে দাও।
17 নম্বরটা।
আমরা যে অর্ডার করতে তাহলে ভুল করেছো।